The committee will come to order. Will the clerk please call the roll?
Edwards.
Here.
Vice Chair Ray. Here. Ranking Sweeney.
Here.
Abrams. Blackshear. Callender. Here. Carruthers. Cross. Petrona checked in. Combar's excused. Grimm. Here. Hoops checked in. Isaacson. Here. Geralds. Jones. Here. Liston.
Here.
Bush excused. Manning. A. Miller. Here. J. Miller. Present. K. Miller. Patton. Here. Pavliga.
Here.
Peterson. Richardson.
Present.
Rob Blaisdell.
Here.
Robinson checked in. Schmidt. Skindle. Here. Swears excused. C. Thomas checked in. Troy. White.
We have a quorum present. We'll proceed as a full committee. The first order of business is to approve the minutes from the previous committee. Without objection, the minutes are approved. Hearing no objections, the minutes are approved and are part of the record. As a reminder to the committee, all supporting documents and testimony can be found on the iPads. I'd also like to point out that written testimony submitted, which is located at the bottom of the iPad, on the iPads. Additionally, if there's anyone taking photos or videos in the committee room, they're required to fill out a media request form, which is located on the tables and up here in front. We will have time for public comment at the end of submitted testimony, so if you'd like to comment and have not yet filled out a witness form, they're also located up here in front on the front tables. I now bring forward House Bill 244 for its third hearing. We are hearing opponent and interested party testimony today. Is there anyone here to testify? Seeing none, that will mark the end of the third hearing on House Bill 244. I now bring forward House Bill 354 for its second hearing. The chair would like to call for its third hearing. Sorry. So it's second hearing. Sponsor calendar. The chair would like to call on Tim Johnson from Cannabis Safety First to testify.
Thank you, Mr. Chairman. If I may approach and hand a package to kind of demystify some of the packaging in the program, that Snickers and Skittles are not on the packaging, and the safety of those, please, if the committee can pass it around. Please.
Sure, just you can start over on this side of the room and we'll pass it around.
No harm to you. Thank you, Mr. Chairman. Edwards and Vice Chair LaRae, Ranking Member Sweeney, and members of the House Finance Committee. My testimony has been submitted. It is rather lengthy, and there are some resource links on there that I'd like, if you get an opportunity, to review. One in particular is inside of a processing facility to show you not only the security in there, but the safety, the handling of the product, the stuff that goes into the testing of the product, the cleanliness, sterilization, and so forth of the entire facility. If you could take a look at that. In reference to the packaging, the concerns that everybody has with all these mythical cartoon characters and so forth, Ohio has a very stringent regulatory compliance rules in place on this. This packaging will show it. We don't do that. We have child-resistant packaging. We do list the profiles of the product, the contents of it, be it a consumable product, that stuff is listed as well as, I believe, the warning for pregnant women or to be pregnant, cautions on that, and the ingredients, as I said, if it's a consumable product. So in the medical program, we are way ahead of any other state that I'm familiar with as far as the way that we do our packaging with children in mind, animals in mind, and so forth. It's for the patient and the patient only. Can it be difficult for some patients to get into? It can be very difficult, especially for those that have possibly an amputated arm, those that have arthritic problems and so forth, but we get through it somehow. I'd also like to address the taxes of where the money is going to be distributed. I don't want to bash on law enforcement. That's my background. It's my heart. But I also would like to remind the committee that law enforcement really doesn't have a financial problem when they're getting local revenue, state revenue, grant money, federal grant money. We just had our Attorney General just received close to $1 billion in lawsuits against Big Pharma. We know what Big Pharma has done to our communities. I believe some of that money could be used. In 2022, I believe it was, our governor gave $250 million of COVID money to law enforcement for training. We also have, I believe it's House Bill 34, 35, if I'm correct there, that had asked for money for law enforcement. And since then, we've had two other House bills, I believe 326 and 345, that have asked for tax dollars. The question comes down to is how much money does law enforcement need for training? We have a state-run OPATA, Ohio Peace Officer Training Academy out here that's state-funded. So how much money do they need from the cannabis community, and why is it the cannabis community's responsibility for some reason to cure all these problems that other industries such as alcohol, big tobacco, big pharma, firearms, and so forth have imposed upon our communities? I'll touch lightly on the THC because there are experts here to touch on that. To drop it, currently in the medical, it's at 70%. Senate Bill 9 this year addressed raising it to 90%. And it's for the medicinal values. To simply not stay the same as what the medical program has at 70% is going to be kind of confusing for the labs who process this. They're going to make medical cannabis over here, adult cannabis over here. Same with the dispensaries. We'll have a distinction of when a patient or someone 21 or over goes into the facility of who's going to get what product, and there's going to be a mistake of giving somebody different products. The biggest thing I'd like to address today is criminal justice reform. While we create this program, I'm asking, I haven't seen it addressed yet, but a rescheduling of cannabis. In the medical program, as most of you probably know, we have rescheduled it to a Schedule 2. We have to at least take it out of Schedule 1 for an adult choice program to get it out from the unjust Schedule 1 where it's placed at now. Now, I understand, Homeland Security or Health and Human Services is trying to go to a Schedule 3. That would be fantastic. A lot of people may not like it, but I can tell you from a law perspective, I'd rather be charged under a Schedule 3 possession than a Schedule 1 possession. It also opens up a 280E tax exempt thing for the license holders. Some of the biggest things I believe that we need to redact in the Ohio Revised Code, Administrative Code, things that go along with a typical street arrest on possession of cannabis that impacts, this impacts the participation of people participating in the adult choice program, as it did in the medical program, where we have still failed in 5 years to provide adequate protection for patients from criminal justice. So we need to look at charges such as drug abuse. When someone's charged with possession, we typically hit them with drug abuse. When someone's charged with possession, we can, if they got a friend with them, we can also charge them for corrupting another with drugs. So what it's called stacking is what we do. Just not a simple possession charge. We had 3, 4, 5 more charges on there. The corrupting another with drugs definitely falls under a gifting and sharing, which I know there's some frowns on gifting and sharing to another. But can I gift and share a cigarette? Can I gift and share alcohol? Sure I can. Unlimited amounts. There's no reason that we can't gift and share with those that are part of the cannabis community as well. Let me close with this. It comes down to the principle of we're really not asking for your permission to participate in the cannabis consumption or manufacturing. We've been doing that in Ohio for 50 plus years without the permission from any legislative body. We've been doing it for 50 years to the tune of about a $4 billion industry in Ohio that's unregulated and untaxed. So what I simply ask is that you stop criminalizing the cannabis community, the cannabis industry as a whole in Ohio, from the patient to the consumer to the license holders. Allow us to be a part of what you consider the normal society, normal community. Allow us to be tax-paying individuals. Allow us to be productive members of society. With that, I thank you for your time today, and I would be more than pleased to answer any questions.
Thank you. We'll now move to questions. Representative Callender.
Thank you. I don't want to draw out testimony today. We have a number of witnesses, so I'm not going to ask everyone questions, and those I have questions of, I'll try to grab later. But Tim, with you in particular, I wanted to start by saying thank you for your involvement over the last many years. I've been getting input from you directly and indirectly, and your wife and your activism for at least 4 or 5 years here, and I know you've been involved longer than that, but you have a unique position with law enforcement background combined with being an advocate for adult use. So I just wanted to thank you for that. Thank you for being a responsible leader in the movement, and we look forward to working with you in the future. A lot of what you talked about today are things that are outside of the issue 2 as it passed directly. And I guess my question is kind of a broad question. Are you okay with some of that being done in a different bill or being taken up at a later date than being included in something that would help, a piece of legislation that would be drafted to help implement issue 2, or are you advocating that it be included in any implementation bill that we have?
Thank you, sir, for the compliments. I do appreciate you for all you do as well. Yeah, I don't have a problem with the understanding that it would be done rather rapidly, as it is a part of the whole industry as a whole. I mean, we're talking about the framework of, the infrastructure of the industry and so forth. To have that industry successful, yeah, we need to address the criminal justice reform. That's part of the industry. Without it, you're operating on a partial industry. So we need to, as I stated, without protecting individuals in some way from criminal justice, or from ending up in the judicial system or at the courthouse or wherever, we have to have some kind of protections. Otherwise, people are just going to simply say, well, I'm not going to get involved. I'm just going to keep getting it on the street as I have been for 10, 15, 25 years. I'm going to keep cultivating and so forth. So the idea is to kind of be inclusive, to try to bring everybody in, give everybody an opportunity, but protect us. If we're going to come in and participate, at least give us some kind of criminal justice protection.
Any other questions for the witness? Seeing none, thank you very much for your testimony today. We will now call on Kat Packer from the Drug Policy Alliance.
Good morning. Thank you, Chair, for the opportunity to provide this testimony. My name is Kat Packer. I currently serve as the Director of Drug Markets and Legal Regulation for the Drug Policy Alliance, and had the opportunity to serve as the first Executive Director for the City of LA's Department of Cannabis Regulation. That may make me the only person in the room that has personal experience leading a regulatory medical and adult use cannabis program and have direct experience implementing and managing a cannabis social equity and jobs program. I've spent the last 8.5 years working on cannabis policy reform with an eye towards making sure that we prioritize social equity, and was very proud to be able to come back home to Ohio and support adult use legalization here, in part because the legalization initiative, issue 2, while imperfect, did center around criminal justice reform and equity. My concern, and I'll use a pun here, I know this is a very serious matter, but we use puns in the cannabis space. But my concern is that through some of the reforms that I'm seeing being introduced in this legislature, we would be moving from puff, puff, pass to puff, puff, police. And that is in total contradiction to what Ohio voters voted in support of. I'll start with the more direct puff, puff, pass. Passing, sharing. This concept of adults being able to share cannabis is critical to cannabis policy reform across the country. I spent some time, probably stayed up until about 3 o'clock this morning, just doing some research so that I could give you all the specifics, but did research on the other 23 states that have passed adult use cannabis. And I'll ask, does anybody have any idea of how many of those states criminalize sharing of the 23? 0. But more importantly than what the other 23 states did, Ohio voters passed issue 2, which allowed for sharing. And I think it would be, again, in total contradiction to criminalize what Ohio voters have decided that they want to do, and it would put Ohio as an outlier for a reason I really can't seem to fathom. Another kind of idea of this puff police agenda. Ohio voters could have chosen to pass a initiative that dedicated resources explicitly to law enforcement. They chose not to. I've heard members of this body and members of the legislature generally talk about how maybe Ohio voters didn't know exactly what they were voting for, but I disagree. I think that Ohio voters did know what they were voting for. They had an opportunity to review what the tax rate was and what they were spending their taxes on. And Ohio voters decided that they wanted to put money towards a cannabis social equity and jobs fund. Unfortunately, some of the legislation that's been introduced would dedicate a significant amount of money towards law enforcement. Now, I recognize that folks may feel as though law enforcement has a responsibility in managing some of these cannabis activities, but I have to tell you that as this shift is happening across the country, law enforcement is stepping back and regulators are stepping forward. These are resources that agencies outside of traditional law enforcement need resources for. I can tell you, even when I was with the city of Los Angeles, I sat essentially part of the mayor's cabinet and sat directly with the police chief, and he articulated to me that they wanted to get out of the cannabis business, that they would love to be able to pass this responsibility to another agency so that they could focus on issues that were of higher priority. Creating and increasing new taxes not only would make it more difficult for consumers to transition and participate into adult use cannabis, but I can't imagine that Ohio voters imagine that every single time they spent money on cannabis, they would be funding law enforcement or the exact type of criminalization that many Ohio voters were trying to reform and step away from. I have specific concerns about efforts to dilute language around the Cannabis Social Equity and Jobs Program. The initiative itself articulated that the money that was supposed to be dedicated to this program would be used for no other purpose. And now there's language in House Bill 354 that would allow these funds to be used for, and I quote, any other purpose for things like economic development, community engagement, social development. These are things that actually arguably could be spent on law enforcement. I would strongly encourage folks to strike out that language that would allow the money specifically that was supposed to be dedicated towards the Cannabis Jobs and Social Equity Program to be used for quote unquote any other purpose. In the same vein, maybe not surprisingly, even the substance abuse funding that was dedicated in this measure is somehow being routed towards law enforcement. In fact, under House Bill 354, the only money that would be dedicated towards substance abuse, the only way that you'd be able to tap into those funds is if you got those funds and had programs and services in jail. I also just want to note, it seems like there's this intention to, maybe as a means to allow folks to transition more directly into the legal market, an idea to allow folks to have expedited access, essentially allowing the medical operators to have automatic and expedited access to participate in adult use sales. And I would just caution that many other states, as they've particularly tried to launch their equity programs, have learned that there's significant first mover advantage that can be given to these medical operators. And while I recognize that folks may want to bring on adult use consumers, that may be a short-term goal and may not consider this long-term strategy of making sure that this is an economic opportunity, not just for the haves, but the have-nots. And I have concern about this simultaneous idea of allowing existing medical operators to have immediate access to adult use, while simultaneously there are these efforts to redirect money towards law enforcement and away from the Cannabis Social Equity and Jobs Program. I was told when I was a regulator in the city of Los Angeles that I should be able to walk and chew gum at the same time, and I know that this legislature can do the same. We can move forward with an adult use program here in the state of Ohio that is responsible and that is equitable. But if we turn this cannabis policy reform into a puff police agenda, we are not acting with the intent, integrity of the voters. You all would be doing something that is seemingly of your own priorities. So my ask is that any types of policy shifts here in the state of Ohio around cannabis policy reform keep equity and fairness at its center, that we ensure that funding that's dedicated to cannabis social equity remains, and that we think very critically about whether or not voters wanted to dedicate money to law enforcement. And if we are going to dedicate money to law enforcement, then I think it's increasingly important that we put parameters around this funding to ensure that we are not funding the same types of harms and disparities that motivated voters to go out to the polls and support this type of reform. I appreciate the opportunity to provide testimony to you today and can answer any questions that you all may have.
Questions for the witness? Seeing none, thank you very much for your testimony today. We will now call on Don Wertschafter from the Cannabis Museum, great city of Athens, Ohio. No Don? Okay, we'll move along. Kathleen McGarvey from the Colleen Cotter.
Good morning, Chair Edwards, Vice Chair LaRae, and Ranking Member Sweeney. Thank you for the opportunity to provide interested party testimony on House Bill 354 today. I am Colleen Cotter, Executive Director of the Legal Aid Society of Cleveland, and I'm here with my colleague Kathleen McGarvey, Executive Director of Ohio State Legal Services Association. We together have the honor of working with our Legal Aid Society colleagues throughout the state, and we serve as chair and vice chair of our membership organization, the Alliance of Ohio Legal Aids. The Alliance of Ohio Legal Aids is a collaboration among Ohio's regional nonprofit legal aid societies. Collectively, we serve every county in the state of Ohio. We provide high-quality, free civil legal assistance to low-income Ohioans. And you can see the list of our members as part of our testimony. Unlike in the criminal justice system, there is no constitutional right to an attorney in the civil justice system. Yet the civil justice system can provide the key for families to access really important things like housing, health, safety, and economic security. Civil legal aid is a combination of services and resources that helps Ohioans of all backgrounds, including those who face the toughest legal challenges: children, veterans, seniors, and survivors of domestic violence, to effectively navigate the justice system. In 2022, Alliance members served 132,640 individuals and their families. Included in that number is that we helped 2,700 Ohioans seal or expunge their criminal records or reinstate their driver's licenses, removing barriers to employment and helping nearly 5,000 domestic violence survivors achieve safety. We help thousands of Ohioans with housing stability through eviction and foreclosure representation. Addressing civil legal issues can be life-changing. Consider the story of George Johnson. Mr. Johnson came to legal aid looking to expunge a minor misdemeanor drug conviction. He'd paid all his fines, he thought he could move on, but he found, as so many do, that that past conviction was a barrier to employment even years later. Legal aid helped Mr. Johnson complete the paperwork to file for an expungement, but lost paperwork and miscommunication back and forth between him and the court meant that he could not move things forward. A legal aid attorney stepped in, represented Mr. Johnson, filed another motion, and Mr. Johnson's conviction was sealed. As Mr. Johnson described it, he had just made a dumb mistake. He hung out with the wrong people, resulting in that conviction that stood in his way to his own prosperity. Because of legal aid, Mr. Johnson is now able to seek employment, free of any shadows from his past. And with the expungement of his criminal record, his fears and frustration of not being able to compete in the job market are alleviated. He has his second chance. Mr. Johnson's story illustrates how legal aid secures second chances. Expungement of past criminal records benefits individuals, families, and communities. It can remove barriers to employment, professional licenses, access to credit, and housing. As you finalize House Bill 354, we ask that you consider the important work of legal aid in your district, serving your constituents. We ask that you direct cannabis tax revenue to expand the reach of our services.
In every Ohio House district, legal aid plays a critical role in helping to remove barriers to employment and support community development. Legal aid helps individuals who have previously been arrested or incarcerated, and their family members who suffer financial harm, overcome the negative consequences of past convictions related to employment, business ownership, housing, health, and long-term financial well-being. Specifically, legal aid assists individuals with criminal record sealing and certificates of qualification for employments, or CQEs, to remove barriers to employment. We represent low-income small business owners in helping to start new businesses and in navigating legal issues with their businesses. We represent individuals at risk of eviction and foreclosure. And we represent individuals faced with wage garnishments, debt collection lawsuits, and those in need of bankruptcy assistance. The Legal Services Corporation's most recent Justice Gap report shows that 74% of low-income households experienced at least one civil legal problem in the last year. More than half stated that these problems substantially impacted their lives. Unfortunately, the report shows that legal aids across the country must turn away 1 out of every 2 requests they receive due to limited resources. This is true throughout Ohio. Legal aids have the skills to serve the needs of our communities and resolve fundamental civil legal issues. The only thing that prevents us from meeting the critical needs of our communities, of your communities, is lack of resources. We have the ability to expand our services with additional resources that the cannabis tax revenue can help provide. Please consider using a portion of the marijuana tax proceeds to boost legal aid services across the state. We are asking for a percentage of the tax revenue that would generate at least $5 million annually. This would significantly increase the number of low-income Ohioans that legal aids can serve. It would bring stability to families across the state. Thank you for your time and your consideration, and we would be happy to answer any questions.
Questions for the witness? Ranking Member Sweeney.
Thank you, Chair, and thank you both for your testimony. My first question is about expungement. I know in this version of the piece of legislation, it's not included, but I'm not sure if you've looked at the language that was included in the Senate. And just with your expertise, do you find that satisfactory to, I don't know if there's automatic or applying that language. Is that the most ideal way in order to make sure that those with specific cannabis-related records, that they can, as quickly as possible, not have that on their records?
Yeah, we very much appreciate that being included in the Senate version, and I think that that's an important step. However, we do have a couple of concerns. First of all, with regard to how narrow that provision is. As we heard earlier, there are often multiple different charges that are layered on, and having the ability to really wipe the slate clean to help that individual. Secondly, the reimbursement method is complicated and would not be our preferred method of providing those services. We would be happy to provide additional language if that would be helpful. Colleen, do you have anything on that?
A follow-up.
Follow-up.
That'd be incredibly helpful. So if you can communicate with our office, I'd love to look at that piece. And then just going to your the heart of your testimony, which is asking for revenue. And I know a lot of us can attest to the work that you do for our constituents. We can't get involved in legal matters, but is often you guys the ones helping. Could you just give us an update on how you guys are currently funding, what your budget is, and what $5 million would look like in that bigger picture?
So $5 million would be impactful, and it would. The beautiful thing about the legal aid societies, all of the legal aids, is that we have a diverse set of funding. We have federal dollars, we have state-based dollars, a very small amount appropriated by the legislature, a larger amount from things like interest on lawyers' trust account, and a lot of private funding, foundation funding and United Way funding, individual funding. So the $5 million would be added to this much larger pool, but every dollar we spend goes to serving clients. So with additional dollars, additional clients will be served.
Thank you, Ranking Member Sweeney. Representative Thomas.
Thank you, Mr. Chairman, and thank you all for the work that you do. I'm a very strong supporter of the organization, and you all have done a lot of things for a lot of people. If you can, based on your experience and the folks that you come in contact with, can you give me maybe some thoughts on what is the pushback on expunging records of something as minor as misdemeanor marijuana abuse? What are you hearing as opposed to the problem?
Well, I mean, I would say and I'll turn it over to Colleen as well. I would say a couple things. The first of all is I think that there's still a lack of understanding as to what folks can seal, and so outreach and education is really important. On that, the rules have changed a lot over the past 5 years, and so making sure that folks understand that. And it can also just be a complicated process. So even if folks know that they're eligible, they may have difficulty with understanding how to file that application. And then sometimes we do see pushback from the prosecutors, just depending on what the range of things are included and how they may read some of the recent rule changes. What would you add?
Yeah, I would just add that I do think the idea of going into court without a lawyer and without good counsel on what it's going to look like, what your form should look like, is really an impossible task to ask people to do on their own. So the part of the pushback is that the justice system that we have created is pretty darn complicated. And so making sure people have the assistance to navigate that is critically important. The reality is that our laws are not self-effectuating. We have to actually assert our rights in order to receive the benefits of that. And I would add to what Kate said, in addition to sometimes prosecutors object for whatever reason, and it's not always clear why prosecutors would object, especially for something so minor. Sometimes, honestly, the judges do not apply the law correctly, the law that you all passed on sealing records. And it requires legal aid to appeal those decisions where judges inappropriately apply the law. And we've seen that across the state where we have succeeded in those appeals, enforcing the law that you all have passed.
One final
Follow-up?
So there's a harm and there's a benefit. Give me the benefits of expunging records versus the harm.
Well, I mean, the benefits are enormous. I mean, we have people every day who talk about the life-changing benefits of getting their records sealed. Whether it is with an ability to get a job, an ability to get a professional license that you were not previously able to get, housing, which is difficult to begin with and can be impossible if you have a criminal record. It's an amazing range. And, we have people, I remember we have a board member who had a charge from 2018, and it blocked almost all parts of her life in terms of and it was a driver's related charge. And it stopped her from getting employment, it stopped her from getting housing, and 5 years later, her life is dramatically different because that was expunged and taken off her record. So I would say the benefits are enormous. I think the harm, especially in a situation where the laws are changing, is non-existent. And I think that, what we're looking at is how do we support those communities, those individuals who are hardest hit by this, to get them to that place of security.
Thank you, Representative.
Thank you.
Thank you, Representative Thomas. Representative Jones.
Thank you, Mr. Chairman, and thank you for your testimony. So let me ask you this question, maybe to help us understand. So of all the expungement cases you folks handle, do you have a breakdown of, what the charges are that they're being asked to expunge or to seal? I think that would be important to know, what you're doing now versus what you could potentially be doing.
So we don't have that breakdown. We'd be happy to provide, although I don't want to overpromise in terms of what our data shows, but we'll look into that. I will say that we are pursuing expungements for those crimes, those charges, and those convictions that this legislature has passed a statute saying you can get that sealed and expunged. So everything that we pursue is under the statute passed by this body. And the answer is we would do more of it with more funding. We are not meeting the need. The need is significantly more than we have the ability to meet. So it's a very clear dollars into legal aid will result in removing barriers for folks with convictions.
Follow-up? So maybe let me ask the question, maybe it wasn't clear. Are you expunging, drug-related charges, what is the type of charges that you are seeing and expunging the most of? Because you're saying there are barriers to housing, employment, and things of that nature. I think for those people that are not, familiar with your work, and now we're saying we're going to expunge possibly, medical or marijuana charges. What are we doing now? What are your charges that you're getting expunged or crimes?
Yeah, there is a whole range, and we can certainly look at what data we have. We don't necessarily track the individual charges, but we can see if we can follow up with you to get you some of those specifics. I would say there is a wide range. We do see a number of driver's license issues. We do see some other minor misdemeanors. It has been expanded over the past 5 years, thanks in part to the changes in the law, or thanks specifically to the changes in the law. I think the other complications are, so my organization serves 36 counties in southeast and central Ohio. And so the data is also dependent on each of the courts, or the clerks in all of those offices, so the data can be a little difficult to get. But for an example, we did a clinic this fall here in Columbus, and in 4.5 hours, we served over 300 individuals who all met the requirements under the current law. So there is a very, very high demand for these services for individuals who are eligible, and meeting that demand is just not possible given our current resources.
Thank you, Representative Jones. Any other questions for the witness? Seeing none, thank you very much for your testimony today. We'll now call on Jody Salvo from Empower Tusk Community Coalition.
Good afternoon. I guess it's morning, huh? Good morning. My name is Jody Salvo. Thank you, Chairman Edwards, Vice Chair LeRae, Ranking Member Sweeney, and esteemed members of the House Finance Committee. Thank you for the opportunity to provide interested party testimony and contribute to our perspective to House Bill 354. I'm Jody Salvo, representing Empower Tusk, a community coalition dedicated to preventing youth substance use, suicide prevention, and the promotion of mental health. I bring to the table a wealth of experience as an Ohio certified prevention consultant, a licensed mastered social worker, and the director of substance use prevention at Ohio Guidestone. My involvement extends to the board of directors for the Ohio Prevention Professionals Association and an advisory board member of the Ohio Statewide Prevention Coalition Association. I wish to highlight three critical areas that we would like to see careful consideration from this committee. Number one would be to direct cannabis tax revenues to funding prevention education and community coalitions in Ohio, the reduction of the proposed 90% THC limit, and also tax revenue consideration for robust data collection around this issue. First, prevention education and coalition funding. We strongly advocate for establishment of a dedicated line item for substance use prevention to support the Ohio students through evidence-based prevention education in substance use prevention and suicide prevention coalitions throughout the state of Ohio. Acknowledging the pivotal role of prevention efforts at the grassroots level, this proactive approach ensures that its students across the state receive comprehensive programming proven to be effective in preventing or mitigating youth substance use. To enhance the local infrastructure necessary for successful implementation, we propose directing prevention funding to county ADAMS boards or mental health and recovery services boards. This allocation will facilitate funding for accredited prevention providers in each county, addressing the current limitations faced by many school districts in delivering comprehensive prevention programming. Moreover, extending prevention funding to community substance use and suicide coalitions will empower these entities to implement targeted strategies tailored to the unique community challenges. Next, I'd like to propose data collection. In the context of marijuana legalization, comprehensive and systematic data collection are paramount to understanding the multifaceted consequences of this policy shift. Prioritizing data collection on youth, use, perception of harms, ER visits, addiction rates, drug-related driving impairments, and educational outcomes is crucial. This serves as a valuable tool for communities. Substance Use Prevention Coalition, Addiction Task Force, and Suicide Prevention Coalitions, as well as established data collection framework, enables these entities to proactively address emerging issues, tailor interventions, and safeguard the well-being of our citizens. Informed decision-making, grounded in empirical evidence, is pivotal to steering our state toward a balanced and responsible approach to marijuana legalization. In recommending a comprehensive data collection approach, we suggest looking at the model implemented by the state of Colorado. Colorado has successfully collected annual data and released an annual report to systematically track the impacts of marijuana legalization. By adopting a similar reporting structure, Ohio can establish a transparent and accountable system for tracking the impact of marijuana legalization. This approach allows for ongoing assessment, facilitates evidence-based decision-making, and provides valuable insights to form policy adjustments as needed. And then third would be the potency limits. We respectfully urge the committee to reconsider the proposed 90% THC limit based on scientific research. High THC limits have been associated with adverse outcomes, including increased mental health issues, suicide rates, schizophrenia, psychosis, and escalated healthcare costs. There are concerns about heightened addiction risks and negative impacts on physical health and intensified adverse reactions. Before establishing THC limits, we recommend seeking input from experts well-versed in research on high THC levels and their impacts on mental health and addiction. A cautious approach to THC limits, guided by evidence-based considerations, will prioritize the well-being of our communities, especially our youth, mitigating potential adverse effects on mental health and addressing the risk of increased addiction associated with high-potency products. Thank you, Chairman Edwards, Vice Chair LaRae, and Ranking Member Sweeney for the opportunity to provide testimony on House Bill 354, and I'm available for any questions.
Questions for the witness? Seeing none, thank you very much for your testimony today.
Perfect, thank you.
We will now call on Thomas Stuber with the Ohio Alliance of Recovery Providers.
Chairman Edwards, Vice Chair LaRae, Ranking Member Sweeney, and members of the House Finance Committee. Thank you for the opportunity to offer comment on House Bill 354. My name is Thomas Stuber, and I am President and Chief Legislative Officer for the Licata Way, Lorain County Alcohol and Drug Abuse Services, serving Lorain, Erie, and Cuyahoga counties. But today I come to you representing the Ohio Alliance of Recovery Providers, OARP, for which I serve as president. OARP is a statewide organization made up of 39 treatment providers certified by the Ohio Department of Mental Health and Addiction Services, whose members work together as a system to help clients move from active addiction to productive citizenship. Our member organizations work to increase access to treatment and develop recovery-oriented systems of care for all Ohioans. Through our professional network and idea sharing, we have created a collective knowledge of best practices for optimal care and share this information with both state and federal legislators. The community behavioral health field has faced increased demand for services with increased staff turnover. This workforce crisis has been exacerbated by both the opiate epidemic, which has only intensified, and the COVID-19 pandemic. More than ever, Ohio needs a robust, reliable, and accessible behavioral health system, and I say that because we know what is coming, having seen it before. After the casinos opened, and again recently with the legalized sports betting, our providers have seen an increased need for gambling addiction treatment. With the legalization of recreational marijuana, we need to be ready to treat those who desperately need and seek our help. However, complicating our ability to recruit and retain qualified staff is a lack of adequate funding. Without adequate funding, we cannot treat the number of Ohioans coming to us for services. Many residential treatment providers are operating at 50 to 75% capacity because they are unable to attract sufficient staff to expand care. More funding is needed so that we may increase salaries for our employees and compete with a market-wide wage growth. I am here today to ask for your help. The good news is that the voters of Ohio already approved it. OARP respectfully requests that House Bill 354 be amended to reinstate Issue 2's dedicated 25% tax revenue funding for substance use and addiction treatment, as well as for behavioral health workforce retention and recruitment. We believe this money should be funded with the oversight of the Ohio Department of Mental Health and Addiction Services, and it should be specifically dedicated for workforce and direct care services. Additionally, we agree that many of Ohio's jails are having to provide substance use treatment services. In fact, some of OARP's providers are the organizations providing those services. With that in mind, we would like to recommend that any dedicated funding in House Bill 354 for behavioral health services in jails have the requirement that the jails contract with licensed community behavioral health providers. This can be done in conjunction with the local Adams Board, but we want to make sure that the people providing services in jail are credentialed and qualified to actually offer those services. Thank you for your time today and allowing me to speak on behalf of the Ohio Alliance of Recovery Providers. I just want to reiterate that an increase in funding to these vital services, especially from dedicated funding source, will incentivize more workers to pursue careers in community behavioral health, retain and invest in the staff we currently have, and most importantly, it will allow providers to care for all those who need our services. Thank you, and I am happy to answer any questions.
Thank you very much. Now we'll move on to questions. Representative Manning.
Thank you, Chair, and thank you, Mr. Stuber. Always so nice to see you, and thank you for what you've done for Northeast Ohio and now doing for the state of Ohio. Just one quick question. You're talking about the 25% funding, and you've talked about how that will go to help increase their salary so that you can keep them here. And I know we have spoken before. How are we coming with making sure that people are being educated so that they are going into these jobs that we need so desperately?
Thank you, Representative Edwards and Representative Manning. Wonderful lead-in for a statement regarding Lorraine County Community College and the work that Ohio or OARP is doing. Right now, we have, through the Ohio Department of Mental Health and Addiction Services and the Ohio Chemical Dependency Professionals Board, Lorraine County Community College, and OARP, we have designed a model program that will permit individuals to receive 2 years of education towards an associate degree through LC3, and that will be tuition-free for them. They will leave without any college debt at the end. They will become certified and then ultimately licensed as chemical dependency professionals. And we believe over the next 2 years, we will have an influx of 200 additional alcohol and drug treatment counselors in the field as a result of this collaborative effort. Youngstown State has also stepped up through some of the Great Minds funding, and they will take these individuals who complete their associate degree and move them on to pursuing their bachelor's and master's degree, also tuition-free. And so we will have an educated workforce, credentialed and licensed, and hopefully help us address this increase in demand for services for addiction treatment.
Thank you, Representative Manning. Any other questions for the witness? Seeing none, thank you very much for your testimony today.
Thank you.
We will now move on to Amy Elwood from Modern Remedies. I want to let the committee and the folks in the audience know that a couple of us have to leave here for Rules and Reference Committee at 11 o'clock, and I think Representative Jones is going to take over the committee at that time and handle it maybe for the remainder until we return. So the floor is yours.
Thank you. Honorable members of the Senate and House, I stand before you, a registered nurse, an Appalachian mother of 4, and a small business owner. I left my full-time nursing job during the pandemic to grow and operate Modern Remedies, a family-owned hemp farm located in East Central Ohio, with my husband, Joey Elwood. I am aware you have 50 other problems to address within this bill at present, and the Level 3 operators are not a topic for now. However, I'm here to share concerns regarding Issue 2 and the amendments being considered regarding hemp farmers. Hemp farmers and processors in Ohio have come together to form a coalition in an effort to see that we get priority access to Level 3 cultivation and dispensary licenses similar to New York. We understand this may not be at the forefront of Issue 2, but it is essential for our industry's future. We as hemp farmers have worked intimately with this plant the last couple of years since Ohio has allowed us to in 2020. We're farmers. We know the plant intimately. We respect the plant. We've navigated and understand the regulatory and testing processes. When you begin sorting out Level 3 licensures, we urge you to consider hemp farmers who have endured their set of challenges. I would be happy to discuss the challenges of hemp farmers have faced, but we don't have enough time today. Most importantly, we are also deeply concerned about the language in House Bill 86. Under Section 928.01, lines 306 to 309, it reads, any item containing more than 0.5 of a milligram of Delta-9 THC per serving, 2 milligrams of Delta-9 THC per package, or any other THC. This level is significantly below the amount to get people high, if that really is the true concern. This type of language could cause a business that my family and I have put our blood, sweat, and tears into to shut down, along with many other hemp-related businesses. Although it was a tough decision to leave nursing, I knew I was still going to have the ability to help people. With our full spectrum products, we've had consumers give personal testimonies saying that they've been able to get out of or stop taking synthetic pharmaceuticals such as Wellbutrin, gabapentin, and even pain relief that opioids weren't able to manage. With this new bill, it could cause all of our products to be restricted. It's important to differentiate our hemp products from the synthetic cannabinoids like Delta-8. We also acknowledge the issues surrounding Delta-9 by weight. We ask that our responsibly produced products do not be grouped with these. We have not used any synthetic cannabinoids in our products and should not be essentially punished. A saying we preach at our business is our hemp is as natural as it comes out of the ground. We do not adulterate our plant in any way because we believe that the plant has so many potential benefits just as it is. Our products are not used by people to get high, but to find some type of relief, whether it be from aches and pains or just plain stresses of life. We are open to further discussions and collaboration. It's imperative that any legislation considers the potential impacts on family-run farms and businesses within the hemp sector. Our aim is to ensure that our concerns are heard and addressed. My husband and I, along with our fellow hemp farmers and processors, ask for your thoughtful consideration in your decision-making. The outcomes of these bills will significantly affect families like ours and the community we serve. We remain committed to sustainable and responsible hemp farming. We also hope to continue to contribute to Ohio's agricultural landscaping and keep revenue here in Ohio as opposed to products from California or overseas if this language were to be included. It would be nice if the farmers were able to cash in on this cash crop this go-around. Thank you to Representative Callender and Representative Hillier for listening to the hemp farmers. And thank you to all of you for listening and considering our perspective today. Thank you.
Thank you for your testimony. Are there any questions from the committee? Seeing none, thank you for your
Thank you.
testimony. We'll now call for testimony Fady Bermitri? It's written? Okay, thank you. How about Jeff Corf? Welcome to the committee.
Thank you, Representative Edwards. Chairman Edwards, or excuse me, apologize. Chairman Manning, is that correct?
Jones, but it's all right.
I
You can go ahead.
apologize. I'm trying to remember all the tags.
We know. You're fine. Go ahead and proceed.
Chairman Jones, Vice Chairman LaRae, and Ranking Member Sweeney, and honorable members of this committee, thank you for allowing me to testify here today. My name is Jeff Korf. I'm the CEO and founder of a company called Galenas LLC. We are a level 2 medical marijuana cultivator here in Ohio's medical program. I'm also here offering some commentary on behalf of a number of the other level 2 cultivators in the state. We own no other licenses in this market. Our business is located at 1956 South Main in Akron, Ohio. We currently employ approximately 22 full-time employees. I'm going to dispense with my background. It's in my testimony. All I'll say is that I'm an attorney. Prior to entering into the cannabis industry, I also was the president of a heavy manufacturing company based out of Youngstown. And so cannabis has not been my only career path. Have had quite a bit of experience outside of this industry. But what I will add is that my full-time role today is as CEO of Galenas. This is the only industry I'm actively involved in. And I'm offering testimony not just on behalf of myself, but on behalf of a majority of the level 2 cultivation license holders here in Ohio, which includes my company, Galenas, as well as Wellspring Fields and Ravenna. Tom Hobson is here to testify on his own behalf as well. Fire Rock in Akron, Ascension Biomedical in Oberlin, Ohio Clean Leaf in Dayton, Ancient Roots in Wilmington, Farkas Farm in Grafton, Ohio Grow in Toledo, Pure OH in East Palestine, and Paragon of Tip City. To begin, we are substantially more supportive of House Bill 354 than we were of House Bill 86 over on the Senate side, which we were opponents of there. The Senate's bill represented a radical departure from the language of Issue 2 that was passed by 50% of Ohio voters. This bill, HB 354, is an improvement over HB 86 in that it maintains a majority of the critical provisions that were approved by Ohio voters via Issue 2. It maintains much of the commercial framework as well as individual rights. However, this is not to say that HB 86 did not make some improvements. We fully support expediting the start of the adult use program from existing medical dispensaries, as prolonging the process will only support the black market and continue to push purchases and transactions across the border into Michigan. From that standpoint, we would certainly be supportive of initiating an adult use market within 90 days or sooner, as was written into House Bill 86. With all that said, however, there are still some areas that we believe need to be addressed, which is why we're approaching this issue today as an interested party as opposed to anything else. As level 2 cultivators, we are the smallest operators in the state of Ohio. We started out with 3,000 square feet of cultivation space, which by any standard and any market is exceptionally small. We've had a size and capacity disadvantage for the entirety of the last 5 years of Ohio's medical program, and that disadvantage is carried over into the adult use program through both issue 2 as well as in the current version of HB 354. Under this bill, level 2 cultivators would be limited to 15,000 square feet of cultivation space and would only be permitted to expand with leave of the Department of Commerce. While this certainly represents an improvement, it is frankly really a drop in the bucket compared to what the size of the market is going to consist of and the total capacity that will be authorized under current language of House Bill 354. So to set the stage for this discussion, the numbers become really important, and to understand kind of what the market is going to look like if this bill goes into effect as written. As it stands currently, there are 37 cultivators in the state of Ohio. 23 are level 1, which is the larger license. 14 are level 2, which is the smaller license. Along with level 3 licenses contemplated by this bill, a fully expanded adult use market in Ohio would consist of just north of 2.7 million square feet of cultivation capacity, of which level 2 license holders would represent a mere 7% of the market at approximately 210,000 square feet. When the medical program was originally set up with 12 level 1s and 12 level 2s, our market share, or our presumed market share, was closer to 12% of the market. And as you can see, we've lost significant ground in the marketplace as additional licenses have been awarded via litigation primarily. So what we are asking for is for this committee to entertain creating a more competitive market and not have the smallest businesses in the state be so incredibly disadvantaged based on the capacity limitation. Thus is the first request I'm going to make for consideration by this committee in the interest of establishing a truly competitive market where small, locally owned businesses can compete with the largest and most well-capitalized businesses. We respectfully submit that a more appropriate cultivation capacity for level 2 license holders is 25,000 square feet as opposed to 15,000, which is, again, currently in this bill. That amount would get us back to the 12% of the market that was originally contemplated when the medical program was set up in 2017. Additionally, House Bill 354 contemplates an award of dispensary licenses as well. My current reading of the bill, as well as of issue 2, suggests that after all licenses have been allocated, that we will end up with a dispensary count of approximately 328 locations. I would argue that this is a fairly modest number for a state the population of Ohio. It's roughly half of what Michigan has with a slightly smaller population. It's about 60% of what the state of Washington has with a significantly smaller population. And it's about half of what Florida's current medical market consists of. Florida has almost double the population, of course, but again, they are medical only. They do not have an adult use market. So by my count, the current version of HB 354 would authorize and award the following licenses. All level 1 cultivators would receive 69 new retail licenses in total. Level 2 cultivators would receive only 14 retail licenses. All current dispensary owners that do not have any other license besides dispensaries would receive another 64 retail licenses, I think. The reason I think is because some transactions had happened. It's kind of hard to understand exactly what that group consists of, but I think 64 is the right number. And then social equity individuals or groups would receive 50 new dispensary licenses. So, as the old saying goes, one of these is not like the other. Of the 197 new licenses that are currently being contemplated by this bill, only 14 would go to level 2 license holders. Now, I think the obvious question is, why should anyone automatically get licenses? We certainly understand that. I think that if the consideration is going to be given to anybody, to any group, that we should certainly be in that mix. And the reason why is that if the goal is to bring a marketplace online efficiently, safely, compliantly, then you need competent operators. There's nowhere better to go than the current operators. However, additionally, level 2 cultivators should receive some additional consideration in the fact that our place in the market is so small and only a very tiny minority of us own any retail licenses as it stands. We cannot marshal the same capital as some of the larger groups in the market, and so purchasing licenses is exceptionally difficult, if not impossible. Furthermore, we will always be at a competitive disadvantage in licensing process relative to the largest businesses in the state. Again, because we're simply much more poorly capitalized, and we cannot afford the same lawyers and consultants as some of the largest groups can. And that's really how this process works. And finally, one single dispensary is just not enough to keep a cultivator relevant in this marketplace. It still represents a very small portion of the market, and it makes it essentially impossible to be self-supporting. So please understand, we're not advocating for the removal of any licenses from anyone. We have good working relationships with the larger level 1 groups, and we believe that social equity licenses contemplated in issue 2 are both valuable and warranted. We're simply advocating for ourselves and attempting to explain the dynamics of what is now a complicated marketplace and what is going to become exceptionally complicated in the future. If nothing changes, however, we will remain outnumbered and outgunned by the largest operators in the state. Thus, as our second request for changes to HB 354, we are respectfully requesting that level 2 cultivators be considered for 2 dispensary licenses and not merely 1. This still does not level the playing field for us, as we will nonetheless be operating at a disadvantage. It does, however, give us a fighting chance to succeed in this market. Additionally, as this committee has heard, and the Senate has also heard, there are a number of independent processors, which is kind of the middle step in the manufacturing processes, that are also seeking some consideration for cultivation space so that they can supply themselves with their own biomass. I think that their request is somewhat warranted. We will concede that there may be a limitation on the supply of biomass in an adult use market. However, we ask that you consider the impact of giving independent processors any level of cultivation space, because what it does is creates the opposite problem for us small cultivators, because it removes a channel of the market. Right now, we have to sell our biomass to those processors in order to have a viable market for us. If every processor ends up with a cultivation license, we won't have anybody to sell to. And so if the consideration is to give independent processors some level of their own cultivation capacity, it has to work in reverse in order for the market to not be upside down. Meaning if independent processors are given cultivation capacity, standalone cultivators must be given processing capacity, because otherwise we will have biomass with nowhere to put it. And finally, we urge you to be modest in your approach to taxation with regard to an adult use market. No market can exist without 2 things: competitive prices and products that people actually want to buy. If we're taxed so as to make us less competitive than Michigan or the black market, people will simply switch back to one or both of those other sources. For this reason, and as my final request, we urge the committee to maintain the 10% point of sale excise tax contained in issue 2 and to not raise the rate or change how it's levied. This concludes my testimony for today, and I would be more than happy to answer any questions.
Thank you for your testimony, Representative Joe Miller.
Thank you, Chair. Mr. Corf, thank you for coming in. Some questions here. Some of the testimony we've heard last week was on the need to be competitive in a competitive market, the need for vertical integration. It sounds like some of that's coming from you as well. And I find it interesting, our body usually spews how much we love capitalism, but then picks winners and losers. And we don't want to see that. At least I don't want to see that. My question to you is, with this vertical integration to help with the processing and the cultivating and dispensing and everything else that goes into it, how will this impact local zoning laws? For some, there may be, this is an agriculture piece. Others are saying, well, no, this is a commercial piece, and the zoning is already in place. Will local entities be able to properly make the decision of how they want to zone your business or identify your business for particular zoning areas?
Through the chair, Representative Miller, fantastic question. The short answer is yes. All the local municipalities are able to make their own decisions with regard to how their zoning works and whether or not we require conditional use permits, as an example, in order to operate in any particular jurisdiction. But I can't say I know exactly how every scheme is set up, but I have seen quite a few of these across the state. And most of the time, a kind of green zone is created where cannabis businesses are allowed to operate. Sometimes it's broken down between cultivation and retail, or cultivation processing on one side and then retail on the other. But most of the municipalities, at least the ones that I'm familiar with, have already done this, meaning they've already creating a zoning scheme that takes these things into account. Sometimes they will just sort of blanket conditional use us, meaning that as long as we're operating in a commercial zone, we just have to go get a conditional use permit for our particular industry, but they haven't zoned us in any different way. Does that answer your question?
If I may follow up, Chair?
Yes, go
Yeah,
ahead.
thank you. Yes, a little bit. So, for example, we have, in the ag industry, the farming industry, we may have, it's zoned agricultural, but they'll have a meat processing right on the side, right, of their cattle farm, whatever. And then they'll have a retail. They're allowed to have kind of like a retail front. The idea, though, is we don't want, for example, a local community doesn't want the meat processing to happen down the street from a few other businesses that it doesn't align with. So they want to keep that out there zoned in the agriculture area, not in the commercial. In this legislation, in current law, and I apologize for my ignorance here, who determines where your business is, this new cannabis business, is going to be placed or restricted to? Commercial, agriculture, how is it today?
So through the chair, Representative Miller, I think I understand your question better. The individual municipalities have total authority to make those decisions. There's nothing in this legislation or any other legislation that kind of mandates what kind of zones have to be set up. So as an example, if a city wanted to say, you can have a cultivation facility here, but no retail, they're completely within their rights to do that. There's no bundling of license types that is required through any of the statutes that are being considered.
So just to clear, Chair, so if I'm hearing this correctly, thank you with that, then they can say, if you're going to have this vertical integration, it's going to happen in an agriculture zoned area, and you're restricted to that in the village, township, municipality, what have you, because on the books right now, nothing unless the number 354, or currently by the statute at issue 2 says that a normal thing we do down here is tell municipalities what they can and cannot do. Are we doing that in any of the current legislation or statutes?
Through the chair, Representative Miller, no, we're not. There's no controlling language in any of the current statutes that are being considered or in issue 2 that would mandate that municipalities have to follow some guideline that is set by the state. It is completely up to them individually as to what they want to do.
Perfect. Thank you, Chair, for that.
Thank you. Representative Schmidt?
Thank you, Mr. Chair, and thank you for your testimony. Before I get to my question, clarification on what you just said. Townships and counties may or may not have zoning. Brown County has no zoning laws, so therefore they're extremely limited on anything that goes in. In my county, Washington Township doesn't have any zoning laws. And so when we talk about municipalities and we talk about townships, we really have to make sure that we understand that if you don't have laws in place to restrict or guide anything, you may not have the opportunity in this bill to guide those processing plants outside of somebody else's area. So I just wanted to clarify that for you, okay?
Certainly. May I respond?
Yes.
Because there is through the chair, Representative Schmidt. So for unincorporated areas or for areas that don't have zoning laws, the licensing process has always been sort of a two-step process. There's local approvals and there's state approvals. And every time there's been a licensing process that's been conducted by the state, there is still some level of local consent that is required, meaning we have to get a form signed by the township or whoever the trustees are, whatever the case may be with that area, to say that they're at the very least they're agnostic to it. I mean, they're not saying we want it, they're not saying no, but there's still an option to say no, basically, is kind of what I'm getting at. The state won't issue licenses to anyone unless there is some consent given from the local jurisdiction, whatever that may be.
Follow up?
Through the chair, I don't want to argue that point, but the state does have the right to ignore that. But really what I want to get to the heart of is when we had decided on medical marijuana, we created a business plan that has now been tossed on its ear with adult marijuana. And we have 3 different groups all trying to compete to stay viable and appropriate. And I would respect that you have your opportunity to remain viable, but also that the processors have the opportunity to remain viable, because right now, if you're allowed to grow and the ag folks are allowed to grow, the processors are not. If you're allowed to be a processor, and the group number 1 is allowed to be a processor, what does it do to those that were just uniquely processors? So what we really need to do when we're implementing the voter's wish is to make sure that we don't disrupt anyone's business activity. Having said that, there has been proffered out there giving processors a limited footprint to grow in, and we're seriously looking at that. What is your reaction to that?
So through the chair, Representative Schmidt, I addressed this a little bit in my testimony. I think there is validity to the fact that processors will potentially have some issues getting a hold of biomass in an adult use market, given the fact that there's a lot of processing licenses out there in the state of Ohio, and I think that based on what some assumptions about demand are going to be, that supply of biomass is potentially going to dry up relatively fast. So I think it's warranted. I think everything you just said is correct. The only thing that I was adding in my testimony is that there are cultivators that are in the exact same position, but on the other side of the coin, whereas we only have cultivation. My company is in this exact situation. We only have cultivation. We don't have a processing license. And so if processors are given the ability to cultivate, but we're not also given the opportunity to process, we will lose that revenue stream because we won't have anybody to sell to, or our ability to sell will be very restricted. And so we're not opposed to processors getting some consideration for their own individual ability to cultivate. We're just saying that it's got to work both ways. If they're going to be given the ability to cultivate to some extent, we've got to be given the ability to process for those cultivators that don't have that.
Through the chair.
Follow up?
Thank you for your input. Just want to make sure that we don't create winners and losers in this. Thank you very much.
Any other questions from committee? I do have one for you, and I guess this is a concern. We talked, we had the expansion. We talked about, for medical marijuana last General Assembly. What is the fear, or is there any fear of, you've kind of alluded to it, processors having a lot more choice to where to buy, and then cultivators having fewer choices, because that balance, how hard is it going to be to find that balance? Because there has to be processors for the product. We don't want to have an excess product that we can't get processed, and vice versa. How do we find that balance? I mean, in your opinion, because you're a cultivator, and if you can't sell your product, there's a problem there. And if a processor, doesn't have to buy it, what are you going to do? I mean, so how do we make sure we keep that balance?
Mr. Chairman, that is a very difficult question to ask. I mean, I think the numbers are really important here, meaning in terms of what the supply and demand kind of equations look like in the state of Ohio. But the shortest answer I can give you is that we're kind of halfway into this process of granting some level of vertical integration for most of these businesses out here. At least that seems like the conversation that we're having. And it's one of those things where we can't do it halfway. We either have to vertically integrate or we don't, because those groups that are not able to have the full vertical and be able to get to the end user are going to end up being tremendously handicapped in an adult use market. And it's not just about dollars. It really is about leverage in the marketplace and being able to make purchases of a certain size that make you attractive, both as a customer in kind of the wholesale market, but also as a producer that's trying to sell into that retail market. And the differences in scale of some of these operations are fairly dramatic. And so that's why I've kind of been trying to point out that we, as level 2s, are the smallest, realistically, operators in the state, and that if we're not given some consideration in this process going forward, that the likelihood that we just get squashed by the much larger and more capitalized businesses, it's real. That's a very real concern for us.
So thank you for that. And so I will follow up, and I understand the vertical integration part, because there, again, you have better control of your product, from start to finish. And, and I've heard from processors, they can't provide a quality product if they can't buy a quality product to begin with. And I think, my colleague just said about picking winners and losers. I think there's a real need or want, I guess, for smaller, folks to be able to get into this business. And I think, we know from the medical marijuana, it was a very expensive business for people to get into. And I think the fear is that's how it's going to continue to be. Is that what you see moving forward? Because I've been to processing facilities, and, it's not cheap. This is not a cheap industry to get involved with. So could you maybe elaborate on that a little bit?
Mr. Chair, thank you for the question. It's extraordinarily expensive. The way that Ohio's regulations are set up, on the one hand, intended to be very safe, very compliant. Most of the facilities, if you ever go into them, are much more like banks than they are like anything else, banks and laboratories, really. Even the grow facilities are extraordinarily sophisticated, which is good from a safety and compliance standpoint. We make very clean product here. But on the opposite side of it, it is extraordinarily expensive. And I can't overstate how expensive it is to be in the market in Ohio and be compliant with the rules that we have here. And so the hurdle is real. The barrier to entry is quite dramatic. I mean, I mentioned at the beginning, I spent my life prior to this as an attorney, and I was the president of a medium-sized manufacturing company, and pulling together the capital just for our little operation was a substantial chore.
Right.
I have said in other testimony, I personally cashed out my 401k in order to make this all happen. That is all real. And so now we're sort of half married to the program that we have. Obviously, we're not going to take licenses away from everybody and reshuffle the deck. But in order to put small companies in a position to succeed going forward, we really have to create that market opportunity for them to be able to access the end user. Because without that, there's too much leverage and too much momentum kind of working against us. And when it becomes an adult use market, it's tenfold the inertia moving in one direction or another.
Okay, thank you. Any other questions from the committee? Representative?
Thank you, Chair, and thank you for coming in, Jeff. I, too, sat through a lot of testimony last General Assembly, and I want to apologize for getting here late. I'm going to go watch your testimony, so I may be asking a question you already answered, and so I'm going to ask it in a way that you can answer something you might not have already said. But again, this concept of the vertical integration, the bill that was passed by the state of Ohio was about even putting money aside to help get more small businesses going. And when you talk about the vertical integration, and let's face it, the bill was drafted by my understanding, I may be wrong, larger growers, out-of-state special interests. Okay, and again, we are here, but what I want to do is make sure we're not squeezing out all of the players, including yourselves. So was there anything you haven't said yet that would help us make sure the playing field is level and is going to allow people that don't want to do the whole tiered stack? Because what we heard last time was, well, the bigger growers aren't selling to us, the processors. They're holding it for their own processors. You know, it's this whole market-driven system versus if we're really trying to regulate and make a fair playing field. What else do we need to do that you maybe haven't said? And I'll go back and watch your testimony.
Through the chair, Representative White, thank you for the question. The numbers really matter, and I hate to bog down these types of scenarios with a lot of numbers because I know it's easy to kind of drift and get lost in them. But from a cultivation standpoint, my license type, the level 2s in the state of Ohio, we have, if you just chop it up as a pie, we have 7% of the market, which is exceptionally small. and doesn't allow us to really leverage our capacity in any meaningful way. And so we've asked that we be allowed to expand a little bit more. That's one of the things we're requesting. From a retail standpoint, there's very few level 2s that have dispensaries in the state of Ohio. And this bill, as it's currently written, would give us all 1, and we're greatly appreciative of it. We certainly need it. We're asking for 2 simply because the way the market works is that just 1 license is not going to be enough for us to be able to reliably sell through our product at the retail point of sale. And then the only comment I made is that if independent processors are given consideration for cultivation, meaning if we're thinking about giving them the ability to cultivate for themselves, it has to work both ways. We have to also give level 2 cultivators the ability to process for themselves, because otherwise we won't have an avenue to sell our biomass through. Those points are kind of the gist of everything that I'm trying to convey right now, but I appreciate the question. I think that this is all in. It sounds very counterintuitive, I think, because we're asking for licenses, but this is very genuinely in the spirit of greater competition. What the biggest, I think, argument against the licensing part of all of this that I've heard, at least on the Senate side, has been that we don't want to create an anti-competitive market. We don't want to have power in the marketplace so, held by a small group of businesses or individuals. And the only way to do that in a meaningful way is to empower the small businesses to be able to compete effectively. And so that's essentially what we're asking for.
Any further questions from the committee? Seeing none, thank you for your testimony.
Thank you very much.
We'll now call on Tom Hobson. Welcome to the committee. The floor is yours.
Chairman Jones and honorable members of this committee, thank you for allowing me to testify here as an interested party regarding House Bill 354. My name is Tom Hobson. I am the CEO of Wellspring Fields, a level 2 cultivator and processor located in Ravenna, Ohio. Before I start, I suppose I could just leave and say what he said, because I essentially agree with everything that Jeff just said. But as a little background, I own a pollution control company in Chagrin Falls, which I started with my father when I graduated from college way back in 1984. In 2017, the opportunity to start a new company in Ohio in the medical marijuana program presented itself. I persuaded my daughter to come back to Ohio from Boston, and together with my son, we applied for and won a level 2 cultivating and processor license. As a matter of fact, of all the levels, we were number 2 scored for all the cultivations in both level 1 and level 2. So, we kind of knew what we were doing, at least in the application. We learned a lot as we went. We started Wellspring Fields with 0 outside funding because I really wanted it to be a true family-owned Ohio company with no outside influences. Investors, they want their money back. And when you're running a family company, that sometimes isn't in the best interest of the company, and it isn't certainly in the best interest of the industry a lot of the times. So things went well for Wellspring Fields until we started to see real consolidation in the market about 2 years ago. At that point, Wellspring was selling to about 90% of dispensaries in Ohio. After that consolidation started, where large out-of-state companies bought most of the independent dispensaries, we were forced out of many of these locations, despite patients still asking for our products in these stores. Our business more than halved. This was primarily due to the fact that we don't have any dispensaries of our own. We have since learned that vertically integrated companies with dispensaries have agreements with each other to carry each other's products, and these agreements shut out the small Ohio operators who don't have dispensaries. I respectfully ask that the House allow the small level 2 cultivators like Wellspring Fields to gain 2 dispensaries so that history doesn't repeat itself. Listen, we'll all do well when it first starts, there's no question. But what happened in the medical market, if this isn't fixed now, is going to happen again in the adult use market. And it may not happen next year or the year after, but in 3 or 4 years it will happen. And this would give us and the other level 2s a sufficient outlet for our products and allow us to compete with large vertically integrated, primarily out-of-state companies. Next, I would like to address the cultivation allotment in this bill. The 15,000 square feet allotment in the initiated statute, while certainly better than the 3,000 square foot allotment in the proposal that passed the Senate, it still falls way short of what we need to effectively compete in this market. At 15,000 square feet, the combined gross space of all level 2s is about 7% of the grow space in the market, comparing that, of course, to about 93% for the larger growers. I would respectfully request that you allow the level 2s to cultivate 25,000 square feet initially and allow the marijuana oversight body to determine later if further expansion would be allowed. This would bring the level 2 cultivators to about 11.78% of the market and allow for a more competitive product in the market, more competition in the market with more competitive products. I would also like to address the potency cap of 50% that was being considered for concentrates. When produced, concentrates naturally fall into a range between 70 and 95% potency. To achieve a 50% potency, the distillate has to be cut. You have to put in additives. Adding in cutting agents is risking unintended consequences and ultimately the health of the consumer. While the state can mandate what those cutting agents can be, there's still no guarantee that the problems won't occur down the road because of them. We learn new things as we go. Stuff that was safe 5 years ago is learned not to be safe now. You start adding stuff into concentrates, it could become a big problem. We've seen it before. I don't want to see it again. Also, there is the illicit market and the availability of products right over the border in Michigan to consider. Since neither of these have potency restrictions and consumers in Ohio are already buying from these markets, a cap on potency will prevent the movement of the Ohio adult user, the Ohio adult use consumer to the Ohio regulated market. They're not going to change. If they can't get what they're currently buying, they're not going to take something that's half as strong and say, okay, that's just fine, I'll pay a little more for it. They're going to keep doing what they're doing. They're only going to switch to a new regulated market if they can get the equivalent product to what they're currently getting at an equivalent price. If the potency is roughly half of what they're used for, they won't switch. And the black market, as well as the Michigan market, will flourish and likely grow. Why would they grow? Well, primarily because possession is now legal. Okay, forcing the consumer to buy from legitimate Ohio sources is not possible. With this enforcement element gone, more cannabis will be purchased at the lowest price and highest potency from the other two markets, one of which is extremely dangerous. Now that the adult use products are legal in Ohio, I would recommend that you eliminate the gap in legalization and product availability. We have a very small window here, and we've seen it in other states. If we wait for full rule promulgation as well as dispensary and cultivation licensing build-outs, then the gap is a huge opportunity for the black market to step in and flourish. The immediate sale of products through current medical dispensaries would help prevent the growth of the black market and allow consumers to access safe products while the rest of the adult use market is built out. The one other consideration is the tax rate. Ohio will receive more tax revenue if the excise tax remains at 10%, as it was in the initiated statute, than if it gets raised to 15 or 20. An excise tax of 20% would make the effective rate with a sales tax of at least 26.5% or higher, depending on the county. Michigan's effective rate is 16%, and the black market's rate, 0. The more the consumer must pay taxes in Ohio in the legal market, the less they're going to buy there. I hate losing to the black market, and I hate losing to Michigan. So,
we all agree, I think.
Lastly, I want to address what was said from the Ohio independent processors on Friday. As a processor myself, I understand the need to have biomass on a consistent basis, and I believe that granting them the ability to produce their own biomass is reasonable. However, I don't believe they should be granted a license to produce and sell flower to dispensaries or biomass to the processing market. Every current cultivator had to go through a vetting process where they were scored on their ability to produce safe, secure flower for the consumer. The independent processors either didn't apply or didn't score high enough to be granted a license. Either way, they haven't proven that they can produce flower safely and securely. If they desire a cultivation license to sell flower to the consumer and biomass to other processors, they'll have an opportunity when the additional licenses are made available. Mr. Chairman, thank you for your work on this issue, and I'm happy to answer any questions that you or the other members may have.
Any questions from the committee? Thank you for your testimony.
You're welcome.
Oh, I'm sorry, we do have a question. Representative White, I'm sorry.
Oh, no, I was late to the games. Thank you, Chair. Thank you, sir. I just want to double check, because what I heard you saying is these arguments were made in the Senate, and the guy before you, Jeff, said the same thing. Why What are the opponents saying? Why didn't your voice get heard over there? What's the other side saying that we're missing here?
What
Well,
issue
just in terms
specifically?
of you getting more grow space and being able to have licenses
You know,
and percent of the market and,
You know, it's funny, we always felt like we were being heard, but then when the rubber hit the road, there was nothing there. Like, it just disappeared. Like, in a period of 12 hours between when something was told to us that it would get in, it wasn't in, and it was gone. I don't know how it happened, and I don't know why they're not listening. We have testified, we have gone there and tried to make the case on what's going on, and I'm not really sure why they're not listening.
Follow up.
Yeah.
what is the other side saying that's overwhelming that argument
Which argument specifically?
regarding why you shouldn't be given the ability to have 2 licenses?
Too many dispensaries, maybe? I don't really know what they said, because I can't think of a good argument against it.
Thank you. Any further questions from the committee? Thank you for your testimony. We'll now call Karen Janes for testimony. Welcome to committee. You may proceed.
Thank you, and good morning, Chairman Jones and Vice Chair LaRae and Ranking Congresswoman Sweeney, members of the House Finance Committee and guests. My name is Karen Janes. I'm a resident in Representative Sweeney's 16th District, and I voted yes on the Voters Initiative too. Thank you for the opportunity to be heard on this very important and historic occasion for the state of Ohio and our country. For all purposes of my testimony today, I will be using the scientific term cannabis to refer to the plant Cannabis sativa L. Marijuana is considered a pejorative term for cannabis used to demonize immigrant people who used cannabis culturally in our country in the early 20th century. As we look at these regulations today, language matters. I come before you, the Finance Committee, as a concerned citizen, an Ohio medical cannabis patient, a mother of 2 young children, a mindfulness, meditation, and embodiment teaching professional for almost 2 decades, and a cannabis specialist with a Master's of Science degree in Cannabis Science and Therapeutics from the University of Maryland, Baltimore. I am considered one of the leading educated cannabis-specific experts in cannabis science, policy, therapeutics, and advocacy in this country. I am a member of Americans for Safe Access, the largest national cannabis patient advocacy organization in the United States, and a voting member of the American Society for Testing and Materials, ASTM, a global multi-industry professional standards and compliance organization. I was an advisor to a national federal regulatory nonprofit organization, and my graduate white paper entitled Creating Comprehensive Informed Cannabis Legislation, a conversation between industry and FDA, received academic and industry accolades. I am an informed voter and an educated participant in the cannabis industry, and I continue to learn every day in this widely dynamic space that is humbling. Today, I'm here to advocate for the spirit of the statute that was passed with over 2 million voices in a 57% majority. Over the last week, discussions have increased the tax revenue to 15% have surfaced, and it is my strong belief that increasing the tax revenue rate to 15% will be the demise of this program before it begins. With bordering states collecting a lesser tax rate on adult regulated products, consumers will find ways to spend their cannabis revenue there. Ohio's tax revenue at 10% keeps the tax revenue in Ohio and tempers the illicit market. Voters elected to fund social equity opportunity in Ohio. For far too long, communities of color have disproportionately been impacted by the war on drugs. The war on drugs was waged against cannabis in the late 60s and early 70s. These policies were enforced disproportionately in Black and brown communities. The American Civil Liberties Union reports that Black men are 3.73 times more likely than their white counterparts to be arrested for cannabis while consuming at the same rate. In minority community, these statistics become devastating and create deep pockets of generational poverty, insecurity, and trauma. Giving back to these communities just over a third of the total revenue for education, training, and access to market participation was an intentional will of this statute. The passing of the adult 21 regulated cannabis in Ohio was a huge success for me and 2 million other consumers and patients to have the freedom legally in their state to consume responsibly, safe, and state-regulated products. I personally am celebrating 15 years alcohol-free this year. I'm extremely proud of that choice that I have made in my life. And in 2016, against my own bias and upbringing, cannabis became an unexpected and wonderful support for me in times of anxiety, sleeplessness, depression, pain, and stress. I embrace the levels of joy it brings me in expanding my creativity. I'm an artist and a musician, inner awareness, and my overall health. Research is just beginning to help us to understand all that cannabis can be as a medicine and an overall well-being therapeutic. I am proud that Ohio has joined the majority of states that are leading with science and democratic processes in cannabis. Issue 2 begins to reduce the stigma, engage education, embrace science, and allow responsible consumption. And in that, Issue 2 seeks to recognize that people who have been jailed far too long for cannabis possessions. Reducing criminality was always an original intent, and using tax revenue for this program to fund new jails for Ohio is not in the statute approved by Ohioan voters, and I strongly oppose to this addition or change. We are all constituents, a part of something together. We are all citizens living within the infrastructure of these regulations, willing experts to partner and grow together in a shared vision. I appreciate your committee and individual honesty, integrity, and transparency. Thank you. I'm open for any questions.
Thank you for your testimony. Are there any questions from the committee? Representative Sweeney.
Thank you, Chair.
Hi.
Thank you, Chair. I just wanted to say, as your state representative, I appreciate you coming out today, and especially, a lot of people's voices are important, but I think that you represent an everyday Ohioan, and getting at the piece of destigmatizing and hearing real stories is, to me, one of the most impactful things to make sure that we get this right. So I just wanted to thank you for coming down from Cuyahoga County today.
Thank you so very much. Appreciate it.
Representative White.
Thank you, Chair. Thank you for coming in. I did want to just ask, the concept of making more tax revenue or less tax revenue based on the 10% or the 15%, we're hearing a lot about that. Do you have any evidence from other states that have raised their tax rate compared to neighboring states? And in fact, are they experiencing less revenue? Because the trade-off is higher tax, you won't sell as much. Do you have evidence from other states? I'm curious.
We do have. I don't have that here, and I'd be happy to forward that evidence to you, but it is very apparent that that happens in states. I believe that that has, I can't give you a state right now, but I do know that that is happening, as well as some of the concerns with regard to, medical programs and not going, like Ohio not being adult 21 regulated, and our citizens going to Michigan to purchase in lieu of our program seeking revenue. So I don't have that, but I do know that that has been a fact.
Follow-up.
Just if you would have any data that you could share with the committee through the chair's office, that would be helpful.
I would be happy to forward that to the chair. Thank you.
Thank you. Further questions? Seeing none, thank you for your testimony.
Thank you.
This time, we'll now call on Ronnie Smith. Is Ronnie here? Thank you. Welcome to committee.
Hey, thanks for having me. I appreciate it. My name is Ronnie Smith, and I'm here because cannabis gave me my life back. After graduating high school, I joined the military, and not long after that, I deployed to Iraq. After returning home, I found it very hard to cope. I turned to drinking and the pills the VA prescribed me. I was still trying to fight this war inside of my head and could not find any way to turn it off. I was using cannabis at this time and started growing it as well. When I started growing this beautiful plant, it connected me to something higher. It connected me with nature, with God, and I began to heal. From this moment on, cannabis became a big part of me. Over the next couple of years, I would have many run-ins with the law because I was always growing cannabis and it was still illegal. So I joined the movement for legalization in 2013. In the past, I fought for war. I'm standing in front of you today to fight for peace. Please allow me and the people of Ohio to grow our own medicine. Thank you.
Thanks for your testimony. And first of all, thank you for your service to our country. We appreciate it, and thank you for being here. Any questions for the witness? Thank you, and thank you again for your service. Dawn Wertschafter is now here from the Cannabis Museum in Athens, Ohio, so we'll go ahead and give you your opportunity at the podium. Thank you.
Thank you, Mr. Chairman. Vice Chairman LaRae. I am Don Wertschafter. I'm an attorney and an entrepreneur in Athens, Ohio. I founded the Cannabis Museum 10 years ago, although it has been my lifetime's work to accumulate the history of medical cannabis. I was a developer of the 2 medicines that are on the international market that are made out of cannabis, called Epidiolex and Sativex. And so I come to you as an expert in the field. The Cannabis Museum itself presents the history of cannabis at an important time. There are many people being prescribed cannabis by their physicians, and it frightens them. They don't know what to do with this. They think this is some new medicine that's going to hurt them. And what we have uniquely in the United States and Western Hemisphere is a collection of the old containers that cannabis came in prior to 1937, when 5,000 cannabis products were taken off the shelf one day. And the history of this, as shown by the bottles and by the contemporary literature, shows that cannabis was a mainstream accepted medicine before propaganda got in the way and pulled it off the shelves in 1937. And we've gone through 80 years of ignorance since. So what I want to do is invite each of you to call us, make an appointment to come visit the Cannabis Museum. I think you'll learn a lot from it. I want to talk today quickly about 10 things I think that the legislature doesn't understand about cannabis. And it is cannabis. It's not marijuana. Cannabis is the proper term. Marijuana is a pejorative. It's a slang word that puts people down, and it's got racist implications. The proper word is cannabis. In Ohio, we spell it marijuana. That's really antique. As long as you're going to mess with this law, why don't you change the word marijuana to cannabis throughout the statutes? It'll be much closer scientifically. The people of Ohio voted to scrap our draconian drug laws, but some senators and House of Representatives members seem to want to take it all back and bring us all back to that failure. We didn't seem to learn anything from the past 80 years of failure. When I was young, 50 years ago, cannabis carried 10-year penalty. It didn't stop any of us from wanting to try this cannabis. These, draconian penalties do not work. And the idea of criminalizing the sharing of weed, that's ludicrous to someone who has shared cannabis before. Sharing is an essential part of cannabis, and any attempts to try to make sharing a criminal offense seems like ludicrous. Trying to make a criminal act of someone sharing a joint, it will backfire on us. Regulation of THC content is written in the present proposal does not make sense either. I participated in double-blind scientific studies of cannabis and its individual constituents, and I was given a massive dose of THC. And over the forms I filled in over the next 2 hours, I reported it totally flat. I had no effect that I could feel from a very large dose of THC. And then given the flavonoids, the other parts of the plant, it had an extremely large effect. So THC alone is boring. And you have to understand that. The idea of 100% THC product would not be attractive on the market. Nobody would use it. It's not a drug of abuse in itself. So the idea of trying to take an extract that comes out of the machine at 80% and mandating that it's going to be 40% in Ohio doesn't make sense to the users. There's nothing really safe that you can use to dilute it down to 40%. And so the problem isn't the cannabis, it's the adulterants in these things. Vaping is a great way to consume cannabis. Vaping avoids the carbonaceous byproducts, the tars from cannabis. It gives you just the essences of cannabis. It evaporates the cannabis instead of using a flame to evaporate the cannabis. It's much safer. It doesn't smell. It doesn't smell up your house. It's not going to light fires. You don't have to deal with ashes. Vaping should be encouraged by the state, not discouraged. The idea of saying that you can smoke in public, but you can't vape in public, that's counterproductive. Vaping got unsafe when people figured out that you could put extracts into a vape pen that was originally designed for tobacco. But as soon as that was figured out, there was a race to the bottom. People went to get the cheapest product that they could. They started adding vitamin E oil, they added coconut oil, and then that got thin, so then they had to add vitamin E acetate to make it thick, and then all of a sudden we had people dropping over from vaping. And the FDA labeled this Evaldi, e-cigarette or vaping use associated lung injury. They found 1,000 people had died from Evaldi right before COVID. The COVID took the momentum away from worrying about that. But it's not the vaping that's dangerous. It's the stuff they put in the vaping. CBD is a great chemical, and it's an excellent medicine. But Ohio has no jurisdiction to try to control CBD as a medicine. That's the purview of the FDA and the DEA. CBD is an active ingredient in a modern-day pharmaceutical. And therefore, it's in their bailiwick. Everything you're seeing now, all this pressure to regulate CBD and regulate all these byproducts is coming from people who went to the FDA, tried to get past the FDA for CBD, and got turned away. They presented their studies, the toxicology studies, and the FDA's conclusion is, no, this does not fit in the market as a dietary supplement. It is not a medicine. You can't use it. But everybody's, intent on it. Gas station gummy bears are not marijuana. Gas station candy bars that look like candy bars but have marijuana in it, that's not our regulated industry. I urge you to please draw a very strict line between the regulated industry that you're enabling, that the citizens enabled, and the distribution of imitation, untested, unsafe chemicals through our gas stations, now our health food stores, and our pharmacies. I'm not speaking against CBD and the products that people make out of CBD. That's, been proven safe, and it's pretty accepted in the marketplace. But people take CBD, they put it into very strong acids and make a chemical soup out of that has all these other chemicals in it. And most of the CBD changes to delta 8 THC. Some of it turns to delta 9 THC. And I want to be sure that when you're regulating the content of delta 9 in these products, that you're not allowing in these delta 8 products, these synthetic cannabinoids that are going to destroy the market for the natural cannabinoids, make people sick. They're untested. There's no FDA approval on it. Nobody's ever done any clinical studies on any of this stuff. This is what the legislation needs to concentrate on, regulating, not natural cannabis. Finally, the homegrown cannabis on the scale contemplated by issue 2 is innocuous. It's not going to hurt neighborhoods. It's not going to affect neighbors. Hey, and when people in the old school used to take over a rental house and fill it up every room with cannabis, yes, they overpowered the electricity. Yes, they could cause mold problems. That's not what we're talking about here. 6 plants is like growing tomatoes or violets or your culinary herbs or whatever plants you have in your house. So that's no different, and we should not treat it any differently. We don't need special regulations on this. The smell from these small grows are not going to overpower neighborhoods. You're not going to have complaints from neighbors at all. We can do this, and we should trust the voters of Ohio. Almost done. The current language specifically identifies money to be spent on addiction research. This is old school language and thinking. If you change this to addiction and medical research, then it opens up lots of possibilities for funding medical research in Ohio. Your speaker was right. From the beginning, he said the House should not rush out a bill concerning issue 2. As you are now aware, these issues are really complicated, and they are going to take time. So I urge caution, and I urge research, and I urge you using the normal voter ways of hearing this and getting notice of the hearings and being able to not rush something through, let the people have input into this. I appreciate the opportunity to speak. And I'm open to any questions that you may have.
Thank you for your testimony. Any questions from the committee? Hearing none. Oh, Representative White.
Just real quickly, through the chair, sir. So you seem very highly knowledgeable. Let me ask you this question. How much do you think the average home grower will produce from one plant? How many ounces do you think, because I've already seen advertisements in my newspaper on how to grow marijuana at home, cannabis at home. So how much do you think the average plant will produce?
It really depends on so many factors. And mostly it has to do with how it's grown and where it's grown and the lighting conditions and all that. Most home growers are going to fail at it. It's not that easy. It is a weed, but trying to grow something inside most people are going to fail. And some people are going to get, very inconsistent results. And so averaging it out, I would guess about 2 ounces a plant would be a good average to assume for these purposes. Yes, given the opportunity, given a lot of lights, given a large space, I could get 4 pounds of plant if I really wanted to. You could do it, but it's not economical or, that desirable. 6 plants per person is a very good number. It's held up in a lot of different states, and it really isn't causing problems. Nobody that has allowed homegrown has turned around and reversed on it.
Follow-up?
Through the chair, sir, just one more quick follow-up. You mentioned about the regulation of CBD and the impure products that are related and what the legislature needs to focus on. If you have specific suggestions, I think we would be interested in hearing, or anyone listening, if we're concerned about illicit products that are unrelated but related, what do we need to be putting in this bill?
Thank you, Mr. Chair and Representative White. I think that the federal government has tried to do this by saying that synthetic products of cannabis are not legal. And that's really all you need to say, that when you stick CBD or any of the other cannabinoids into an acid mixture and you tweak it around chemically, you're creating synthetics. One of the problems is you're creating a lot of different synthetics. It goes a lot of different directions. It's not a clean reaction. And so you're getting some THC, you're getting some delta 8 THC and some delta 10 THC and and who knows what. It's not really been tested, characterized, and some of these minor constituents, we have no idea of their toxicity.
Any further questions from Representative Richardson?
Thank you, Chairman. And I was reluctant because I know you've been here a while, but I respect your history. You talked about the museum, and one of the things I've been hearing a lot about is how the former level of THC was X, and in the 60s that THC wasn't harmful, and now the THC levels are harmful. Because you run a museum, I thought I would ask you that question. How has THC evolved, and what is the impact on the user?
Chairman LeRae and Representative Richardson, thank you very much for your question. THC, cannabis has not really changed in 35 years or 50 years that I've known it. It really has not changed much. We've gotten better at growing it. People are more connoisseur in their expectations. We're not smoking ditchweed or, stuff that's like bailed up in Mexico anymore. It's all become pretty local. You can't sell inferior weed very much in the market. The market's become sophisticated, but what that's done is just make the product purer, better quality, doesn't have the molds and the mildews and things in it that we found acceptable when cannabis was really hard to get in the 70s. It's only increased in quality. There isn't any real breeding program to create more maximum THC levels, and it really wouldn't do any good. If anything, all the breeding that's going on has to do with the secondary compounds in cannabis, the flavonoids and the terpenoids. These are things that are considered safe. They are used in medicine or inhaled in medicine. So those aren't really the concerns. And these flavors in cannabis are really what contribute to the effect. And without it, flavorless cannabis, old cannabis is, not really desirable and not really wanted by the people. I hope that answers the question.
Thank you. No further questions.
Thank you. Any further questions from committee? Thank you for your testimony. Now we'll call upon Joshua David. Welcome to committee. The floor is yours.
Hello, and thank you for the opportunity. I'm blessed to even be up here and have a chance to have a conversation like this, so thank you. My name is Joshua David Kroeger. I started my professional career or academia in natural resources management from Hocking College. I followed that up with an environmental science degree from the University of Rio Grande, and I followed that up with a Master's of Science in Sustainable Agriculture from Ohio University. I've been a guest speaker at Donnie's Museum. I have recently took a job as a cannabis history instructor at Hocking College, and I'm also a founder of Soiled Obsessions, an agriculture and horticultural consultation service. I know very little about this political process and how things are done here, admittedly. I have no cannabis cultivation license. I have no cannabis processor's license. I don't even have a farm. So why am I up here? I'm up here because I feel I can offer a unique outlook from my sustainability work. So I try to look at this from a farmer standpoint. And I'm not just talking hemp farms. I've worked on perch farms, mushroom farms, pawpaw farm, produce farms, tree farms. The list goes on and on. However, I will say hemp farmers are very passionate people, and every one of the farms I've been invited on and every one that I've went to look at, these are upstanding people that want to do the right thing, not only for their not only for their pockets, not only for their companies, but also just for sustainability reasons. So like Donnie touched on there, the synthetic cannabinoids and the Delta 8 discussion. Okay, the House Bill 86 has some questionable language on that, where I think you're really confusing these Delta 8s that have been grown in a non-sustainable manner. Just a note, if people aren't aware on how Delta 8s reach our market, It's grown on mass fields. Cannabis plants can contain a little bit of Delta-8 naturally, but that ain't what we're looking at in stores. We're looking at a product that's grown in abundance, and then the use of hydrocarbons is used to extract this Delta-8, or acids are used to produce that. I am up here because I'm worried that that's being confused on the House Bill 86 with your language of full spectrum hemp products and edibles. Some of the farms I've been on, including Joey's, including Matt from Canopy Relief, including App Girls, all these are small family farms. They had the opportunity. They could have bought Delta-8, and they could have enhanced their products with this Delta-8 to make more money, but they chose not to because it was morally and environmentally irresponsible to do so. So I see this language kind of affecting these farmers who are producing gummies using no synthetic cannabinoids, and they're not using hydrocarbons for this extraction process. They're doing things the right way. I don't think they should be affected by this in such a way. So basically, half of these products will become illegal due to the irresponsibleness of the Delta-8 market, which is not even the same discussion. So that is definitely something I wanted to touch on. And a question I heard brought up earlier about, has these THC levels increased since the 60s, or how has that drug changed? Well, maybe even if the potency has gone up, part of the issue right now is consumers are buying based upon the percent of THC. And they're doing this because we're coming off of a black market, so they want to get bang for their buck. The entourage effect and tests done, blind tests done, support the fact that people actually prefer a lower THC product. Consumers are buying this because they don't know any better. They think they're buying, on an economic standpoint, a more THC per dollar. Whereas the real issue is that THC at these percentages aren't dangerous. And the longer that this market is utilized, you'll see this growth in THC stop because people want the flavor associated with it. So the higher the THC, the less flavor, the less aromatic compounds, the less terps, flavonoids, all that stuff associated with it. So that's something I wanted to touch on. And I wanted to touch on, once again, hemp farmers. These hemp farmers that are going to be affected by this House Bill 86 number are the same hemp farmers that can help you close that gap between the same gap that we've talked with other members that have come up here today. The market's going to need cannabis. The hemp farmers already have the hemp infrastructure to do that. I think they should be considered in this discussion because they can help roll out that small scale, hey, there aren't winners and losers type situation. Well, why don't we give the family farms that are still going to be family farms, whether hemp or cannabis exists or not, these are farmers. These are people that really can have an impact on our local communities. So I'm up here more from a sustainability aspect. That's my background. And sustainability doesn't stop with the economics. There's three pillars of it. There's also the social and the environmental impact. So I urge you guys to look at the language in 86 and start to figure out how you can separate these synthetic cannabinoids that got the bad rap for this. And now these farmers in this room are paying the price for that. I don't think that's fair. I really appreciate my time up here, and that's basically it in a nutshell. I could ramble on forever, but that's my points. Is there any questions that?
Thank you for your testimony. Are there any questions from the committee? I do have one question for you. I mean, is there a real problem? Is there a fear, and I know hemp farmers as well, will this put them out of business, do you think, if they're not included in the conversation?
Yeah, absolutely. A lot of them. And that's hurting small town USA, you know, at the expense of MSOs, you know. So let's face it, like, there's multi-state operators that come in here to gobble up the market, And then there's us farmers, family farmers, who need help. This is the opportunity to help that, especially in southeastern Ohio and Athens and Meigs. It's like these communities have been devastated and impacts far outside of big ag. You know, this is an opportunity to help close that gap and help bring money to the communities that need it most. Meanwhile, having the people that did the right thing, even when they didn't have to, even though there was loopholes in this law, like these people held true. Like I really, really strongly encourage consideration, similar to that we see in New York, to where hemp farmers are granted priority access to THC licensing. You know, if not, I mean, we've already started this consolidation of big business going on. Can we get the little guys a shot at this? You know, that's all they're asking for is a shot. It's already hard in agriculture. This was the opportunity to help promote that system that's already hugely impacted.
Thank you. Representative White?
Thank you, Chair. Thank you, sir. Just quickly then, could you provide specific sections of the bill that need changed based on what you said the problems are? With the, not here today, but if you could send it to the chair's office, what's the synthetic thing that we're going to be hurting by doing X, Y, Z? You know it inside and out. This may move quickly, may not, but we need the language as soon as possible. And then suggested sections of allowing the hemp farmers to have more of a voice. And then just to Rep. Richardson's question, you mentioned, well, the potency may have increased. I know I've been hearing for years from law enforcement and others, it's not your father's pot. It's different potency and different strength. So if that is a true statement, why is that? And do we need to be concerned about things that are being added to the product as we regulate?
So as Donnie touched on, the potency, and like you said, it ain't your grandfather's pot or whatever, the potency has gone up, but that isn't due to the plant. I mean, there are great breeders this day that are advancing the capacities of this plant. However, it's more so due to the growers. You know, the growers are getting better at maximizing the total THC out of this pot, similar to when alcohol hit prohibition. The main goal was stronger, 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 higher percentage alcohol. That's been the breeding goal for decades. Once in a legal system, like I'm not like sitting around like wanting moonshine, you know, I'm drinking like light beer and stuff, you know, like it isn't about that high potency anymore. It becomes about experience at that point. So I hope that answers your question. If not, let me know, and I will gather as much specifics on the Delta 8 scenario.
Yeah, so Chair, just to clarify, the potency, the THC has gone up.
Generally speaking, yes. The THC has gone up from my experience. Now, I know, you know, I don't collect data on this, but from what I've heard, from what I've collected, the THC has gone up, but still we're sitting at a threshold now where how much more can THC go up in flower? So right now, people are hitting these 30% THCs on flower. Like, if it goes up anymore, there won't be any fiber left. Like, I don't think, you know, like every time a THC percentage goes up, that means there's less flavor associated with it and less cellulose, less every other component of that plant is going down. The actual biology and physiology of this plant can't actually withstand going up any, I mean, you would have to be like maybe a breeder 100 years from now could get THC at 50%. But once again, it's going to be at the expense of other medicinal and therapeutic uses.
Representative Thomas?
Thank you, Mr. Chairman. You just brought a question to me. Given all of your experience, and obviously you're very well learned in this whole area, do you think it would be wise for us as a body of legislators to take our time and get as much information as possible before we just start putting this out in terms of regulatory processes, and to make sure we don't leave out the small guys And I think you hit on it with priority to those that are currently here in the state of Ohio trying to do this.
Yeah, so I do feel well-versed in a lot of areas of this plant and education. However, with that question, I'm glad I don't have your guys' job. I'll say that, because like when I'm looking at what you guys have to deal with and juggle, man, I respect it a lot more. I think some of the moves that have been made to go ahead and let consumers get this product now and keeping the home grow is very beneficial. I don't know what the implications of slowing it down at the expense of this would mean for other parts of the bill, I guess. But I do think the whole Delta 8 and the full spectrum hemp issue is a major priority, because you're going to be, right off the gate, you're going to be saying bye to the little guys, the people that have tried to do this the right way, and you're going to be saying hello to outside interest coming in. I mean, it's a fair game and all, but it's just nice if we could, if us real farmers could get a chance to, let's not forget, this is not just a business, this is an agricultural crop, like this is a real plant. So if the farmers that have been doing this can, you know, have a spot, I mean, I think they would all feel blessed to have that opportunity.
Representative White?
Thank you, Chair. One last question, the same question. Once a home grower gets going, how much per plant do you think they'd be able to produce?
Okay, so you could produce as little as a 1/4 ounce. I mean, I've seen people produce cannabis plants and have like 1 gram of bud on it. Now, like Donnie really touched on it well. It's the lumens and it's the light and it's the total micromoles that that plant receives. So if you took one 1,000 watt light and put it over top of a plant and you kept that plant in vegetative state until it was as big as this room and then flipped it, you could get a couple pounds off that. But that's going to be off the expense of not turning over more crops. So most home growers are going to want to get that plant vegetated, and then they're going to want to flip it to flower because they need their medicine. So on average, I would say 2.5 ounces, because then you could do it 5 times a year. Versus, hey, I got to grow a plant that takes 8 months this long to produce this yield.
Chair, doing the math then, 2.5, if you're really trying to get that, 5 times a year times 6 plants would be a minimum that we could look at. So that is a lot per household. Per person is 6, per household 12, but no need to further. I know we need to move on. Thank you.
Thank you. Representative Richardson?
Thank you, Chairman. I believe that Representative White asked my question. I will just follow up with, do you support a 6-plant homegrown?
Actually, my consumption is large, so that seems very minimal to me. However, on average, for the average consumer, I think, 6 is the bottom end of that. But, I don't, like I said, I respect you guys, and I'm glad I don't have to make that decision.
Thank you.
Thank you. No follow-up. Thank you.
Further questions? Thank you for your testimony.
Thank you.
Thank you for being here. Next, we'll call Saraka Bryant. Welcome to committee.
Thank you,
Floor is yours.
Representative Jones. Thank you. Thank you, committee. So, thank you for allowing my interested party testimony before the House Bill 354 of the General Assembly, calling for changes in the adult use cannabis law passed by Issue 2 by the people. I don't agree with the Assembly making these drastic changes to Issue 2. I'm an active community organizer for cannabis causes. I'm a founder of Grassroots Ohioans and helped in the successful passage of several cannabis decriminalization ordinances, including the Athens Cannabis Ordinance in 2017. I live in Athens, and since the passage of TACO, I can safely say that we've not had any uptick in crime, poisonings, death, or injuries from cannabis in our community. Not just the citizens of Ohio right now, but the entire world is watching these changes as your body so urgently moves to redact the will of the people. It's unusual, having had months to make these changes before the election, that now the reform of the people's will is an emergency. Ohio's paying attention. We came out in droves in August on an off-year election just to remind you all that we understand that 40-60 is not fair instead of 50-50 to pass legislation. And we came out again in November because we want equal access to cannabis and we want equal access to jobs in the industry. I'm president of Cool Digs Garden Supply in Athens, Ohio. We are a woman, minority-owned business. We supply equipment and have done consulting with some of Ohio's cultivators, as well as university greenhouses and organic greenhouses in our area, growing everything from organic sprouts to medical cannabis. We provide internships, class credit hours for students enrolled in Hawkins College cannabis program. We're invested in helping our community safely grow their foods and their herbs at home as they're choosing and commercially. I'm pro-business and I believe in a free market. I don't think that the changes in issue 2 are allowing for a free market. Even while owning a garden supply, I voted against the monopoly amendment on the ballot for cannabis in 2015. The majority of Ohio did, because it was not fair and it was not equitable for Ohioans. Contrary to the rhetoric coming from the governor's office, issue 2 was carefully scrutinized by Ohio voters. Many of us who voted down the monopoly voted for issue 2 because it allows for social equity. It allows for new business opportunities for normal Ohioans. The removal of the social equity language from this law will effectively steal this opportunity from us. Ohio voted for issue 2 because it allows adults to share their cannabis with other adults, just like their homebrew beer. This is part of cannabis culture. We read and approved the section that affirmed that cannabis offenses would be civil and not criminal offenses. We voted for issue 2 because it allows for 12 plants if there are 2 adults. Michigan, by the way, allows for 12 plants per household. Ohio voted for social equity. Ohioans want a fair playing field. We want the social equity clause intact. We want the harm and criminalization of cannabis users to end. The spin that social equity means criminals can have jobs is not an accurate depiction of this law. It's shameful to misrepresent the law in this way. It's demeaning to cannabis users who were charged for crimes that society no longer wishes to criminalize. It ignores the equal access for impoverished communities. Your job right now should be to implement the programs Ohio approved, not to slash its key components and cut the amount of plants people can have in half. There's no good data for doing this. If that sort of requirement becomes necessary, implement it at that time. Changing the people's law now is unjustifiable. And the narrative that the people are too stupid to understand what they voted for is frankly offensive. I urge you to vote against all changes to issue 2. Set up the law as outlined by the people's will. Wait and see if the concerns you have are even relevant in 9 months. The Ohioans I speak with are fed up with the state's attempts to circumnavigate the will of the people and limit our rights and our choices. Cannabis is more popular than politicians. Ohio's first sensible marijuana ordinance passed in 2015 with over 70% of the vote in Toledo. Taco passed in Athens in 2017 by 78% of the vote of the people, higher than any of our electives received in that election. Even in Nelsonville, 2019, the Nelsonville marijuana ordinance received a higher percentage of the voters than our Representative Chairman Jay Edwards, receiving over 60% of the vote in Nelsonville. I am confident that Ohio will continue to come out to vote for cannabis. Ohio doesn't want this law modified. This is the law we voted for. You can stop the steal right here. Please vote down House Bill 354. Do your best, take your time, and implement the people's choice as passed in issue 2 as best you can. Implement Ohio's adult use program as designed by the will of the people of Ohio. Thank you for your time. I'm happy to answer any questions you may have.
Thank you for your testimony. Are there any questions from the committee? Representative Thomas.
Thank you, ma'am, for your testimony.
Yes, sir.
So help me understand. What you're saying is that the people voted for the bill, the passage of the marijuana. We have to put regulations in place.
Sure.
Based on what the people voted on. And this is what we're trying to do as best we can, looking at all of what has happened around the country, Michigan, Colorado. We want to put something in place that will meet as best we can what the people voted for. But we don't want to, I don't want you to think that, I'll speak for myself, I don't want you to think that I'm trying to not do what the people ask us to do, but we got to put regulations in place. And so would you agree that in doing that, we need some time to do that?
Thank you, Representative Thomas and Representative Jones. I do believe that time is required. I think that everyone in this room and those representatives that are missing need to take a good hard look at the bill, because introducing this House Bill 354, it doesn't reflect what the people voted on. The people didn't vote for over 70% of our tax revenue to go to law enforcement in 4 different specialty funds. The people didn't vote for higher taxes that are going to weigh down our cultivators and send people back to Michigan. The people didn't vote for half of the plant allowance that you guys are now offering. So, yeah, I understand that what we voted on is a regulatory outline, and I would only request that that outline is utilized and not cut up by fear-mongering and propaganda.
Thank you.
Other questions from the committee? Representative Hoops.
Thank you, Mr. Chairman, and I appreciate your testimony. Here's my dilemma. My district up in Northwest Ohio voted against this. Close to 60% voted against this. So how do I react to this? Because the district that I represent said no to this. And I know the whole state said yes, and that's what I'm going to go with. But I'm going back home to a district that said they don't want to see this happen in the state of Ohio. So how do I respond to my constituents in dealing with this issue? Since, you talked about, this is the voice of the people. Well, for me, it's opposite of what you're supporting.
Thank you for your question, Representative Hoops. Can you tell me what district you represent?
I'm in District 81.
Is that
It's
near
up
Toledo?
in Williams County. It's west of Toledo. It's Williams, Henry, Fulton, and a little bit of Defiance.
Do you have Vermillion in there?
No,
Okay,
no.
so they worked on a cannabis
I always say my
ordinance.
district, Mr. Chair, I always say my district protects Ohio from Indiana and Michigan. We didn't do
Well,
well with Michigan this
No,
year.
they're winning our tax dollars right now.
No, no, Mr. Chairman, I understand all that, but my question is how, because I'm trying to understand this, and I think we're taking our time to figure out, okay, this is what the people said, and that's why we're going through these hearings. But I'm just saying, that's the dilemma I go back to with my constituents, saying they didn't vote for this, but yet I know the whole state did.
Right. Well, Representative Jones and Representative Hoops, I would say that that's the outline of democracy, is that the people's voice wins. We get to vote. Each one of us gets one vote because 50-50 is fair. And when over half of our population votes for something, then it becomes the law. And if they're not happy with the law, then they can work to change the law just as hard as all of the people that worked to pass Issue 2 and our other cannabis ordinances. I would also say that, maybe having some real information about, statistically 0 deaths from marijuana would be something that you could introduce. Marijuana is not dangerous. It's safer than alcohol. That's facts. There's a lot of people that grew up with, in times of prohibition, with very little information because there's not even information to offer. That's not now. We've had Ohio's medical program in place since 2016. Surely you have dispensaries in your district? No?
Well, there might, I'm sorry, Mr. Chairman, with medical,
With
I think there
medical,
might,
yeah.
I'm not sure where they're located, but.
Yeah.
No, I'm just, Mr. Chairman, I'm just saying, I appreciate what you're saying, but just realize,
Yeah.
even when we had the issue 1 in August, they also said, we think it should be 60%. And that was up to like 60% of my constituents said, yes, it should be 60% in changing the Constitution. So,
Wow.
so we have different parts of this state is very diversified, so. But it's a great state, so that's what makes
Well,
it interesting.
The other thing I would add, sir, Representative Jones, is that regardless of whether or not we have legal recreational cannabis, we have cannabis use in your district, and cannabis that is regulated is much safer than cannabis that is illicit.
Thank you.
Thank you.
Any further questions? Thank you for your testimony. Thank you for being here today.
Thank you.
We'll now call upon Keith Olson. Welcome to committee. The floor
Yes,
is
sir.
yours.
Hello, my name's Keith Olson. I'm from Criminalize Racketeering Against the Public. In my day and age, you couldn't, cannabis users couldn't work, go to school, keep a job, have kids, own a firearm. Thanks to Ohio Issue 2, all that might change. So I thank you. And anybody that contributed to tax and regulation should get a pat on the back right about now. Unfortunately, after legalization, we still can't work, drive, go to school, babysit, or own a firearm. A lot of these rules are being made for commerce and not for the people. People say nobody should go to jail for a plant. I say no one should go to jail for a plant except for the home growers. The licensees, the lawyers, the politicians, they got to be protected. They need to be protected. We must enable politicians to take cash payments directly from the lobbies that brought these bills here, with no fear of prosecution. We need to cut out the middleman and streamline these lobbies so they can effectively buy a place in commerce. We need to end off the cooling periods for the lobby. Politicians should be able to implement their plans the day they leave. If not, start before they even leave. Why not? That's how we'll get things done. The initiative allows the pharmacy board to promulgate rules. Promulgate. Did I say that right? I'm not even sure what it means. I don't know the voters know what it means. If they had, they would not have voted for adult use. I would like to know who in Ohio is going to be the next Batman. Still a little early to tell. Batman is a code name that the lobbyists use to bribe politicians. They call him Batman after the Rolex Batman watches they give him. The Canadians will fly him up, buy him Lambos, give him some blow, and even a prostitute. You want a license? It's really that easy, guys. Just get a video of the administrators, like Michigan's Rick Johnson, in a Batman suit with a prostitute, and you're in the game. The legislature has no duty to correct the ambiguities of this act. If you cannot understand these laws or the pitfalls created by the state, then you shouldn't have voted. Remember, voting is consent. Ohio police must entrap and jail as many people as humanly possible. Entrapment by estoppel applies when an official tells a defendant that a certain conduct is legal and a defendant's dumb enough to believe him. People will say, I thought that this was legal, on the Grey Goose, on the way to prison. Citizens have no criminal intent or no mens rea with regards to cannabis licensing. Mens rea is the state of mind required to convict a defendant of a crime. Citizens are not making a living thumbing their noses at federal law. Some of the people in this room are. Their guilty minds are protected by the same very laws used to convict an innocent mind. Law enforcement will absolutely send people to jail that believe they're in compliance. And I'll blame all of y'all. I'd like a little lesson in mens rea. Please, if you'd all join me, I'd like you to raise your hand if your business model violates the Controlled Substance Act. Come on now, anybody? Nobody? I think we've identified the problem here. The Detroit River has become the new Rio Grande. Our elected officials are partnered with Canadian industry on both sides of the border and are supplying the entire U.S. with their trade groups. Countless companies like Michigan's Pharmaco have been proven to pay to play in the Johnson case. Pharmaco entered 3 tons of unregulated cannabis into the state's seed-to-sale system in one entry before selling to Canadian corporations for $500 million. Companies like this have compromised every state. I would like to thank the Department of Justice, FBI, CIA, DEA, and especially the SEC and Wall Street. Thank you for turning a blind eye to international crony capitalists, drug traffickers, money launderers, and sex traffickers. Keep up the good work. I have a few suggestions to correct some of the premeditated ambiguities in the Act. First, Ohio needs to approve whatever chemicals Scott's Miracle-Gro tells them to. These companies need to produce chemicals and seeds without FDA approval to make enough money to buy FDA approval. It's the process. Second, all these decisions you're making affect world commerce. Germany, for example, is a great example of crony capitalist cannabis corporations partnered with corrupt officials impacting worldwide cannabis commerce. A simple yes vote for the country of Germany puts these companies that are lobbying these states up 20, 30%. A no vote in Germany puts them down 30%. That just happened last week. You guys have a lot of power to affect these markets. We must allow these companies who made billions of untaxed dollars access to the SEC and Wall Street. Got to let the money in. Third, we can trust the manufacturers just like we trusted the cigarette companies. No government oversight or testing is necessary. The naive citizens have put their faith into the elected officials. Fourth, roadside testing for metabolites and drug recognition experts must be funded with all this tax money you're getting. Give it all to the cops. If there's an accident or if there's an accident with injury, the stoner should face life in prison without the possibility of parole. Let's go ahead and codify it now. 5 nanograms is murder. You're going to prison for life. That's the way it's going in every other state. Let's also remember, drug trafficking and money laundering is now a civil fine for a select few. Those who pay to play must not face criminal charges. Duffel bags of unregulated cannabis and cash are civil infractions for a select few. Eventually, the governors will divvy up all the money and purchase favor in the federal government. I think a lot of the licensing going on here is premature. We're talking about local growers. In the end, cannabis is going to come from the third world as soon as the feds legalize it. People talked a lot about expungement today. I don't believe in expungement. I believe in expungement's just another way for lawyers to collect fees. Lots of states can put a 10-year waiting period. Cannabis felony can't be used against you after 10 years for housing, licensing, anything. And that would save, just a bunch of money for the lawyers. As far as the processors, these local processors aren't going to be here in 20, 30 years, guys. All this is going to come from the third world. All of it's going to come USDA, shipped into our country, and divvied up. I do appreciate your time. If you have any questions, I'd be happy to answer it. I do notice that, that a lot of the money has left the building, and along with it, a lot of the representatives have as well.
Thank you for your testimony. Are there questions from the committee? Hearing none, thank you for being here today. Our next individual will be Wendy Noble. Is Wendy still here? Then we'll move on to Francis Torrefo. How about Sean McGlynn? How about Nicholas Kroeger? Mary Alger? John Lutz? Mary Jane Bordon? All right, we have a winner. Bingo. So.
I'll be happy to come up here. Thank you so much.
All right. Welcome to committee.
Thank you. Pardon me?
Welcome to committee. The floor is yours.
Thank you, thank you. I do have my testimony here that I'd like to read to you, but I thought what I'd start with, and this isn't in my testimony, is an explanation of the THC percentages that Representative Richardson asked about. If I may please address her. Thank you, Representative Jones. Yes, where this comes from is there was once, or I think there still is, the University of Mississippi was granted a sole license for growing and researching marijuana in the United States. And this goes back to about 1970. Now, what they did with, I would say approximately around the 1970s and early 80s, is they began to collect marijuana samples from various agencies, police agencies from across the country. I can't really name exactly where they come from or whatever, but these agencies would send their samples to the University of Mississippi, and they would analyze it, okay? Now, a lot of times what these, and this is before people were really kind of educated about this, but a lot of times what we think they would send in was what they call ditch weed. All right, basically marijuana that's growing feral, okay? So they take this in and they analyze it, and you get percentages like 6%, okay, THC, or maybe even lower, 3 or 4% THC. So you're looking at that now as your baseline from approximately, let's say, 1970 through the 80s. And they may still do it, but I think it kind of became out of favor once we got into legalization, starting with the medical in the 2000s, then going to adult use for Washington, Colorado in 2012. I would suggest that those numbers, when they're trying to make a comparison like what it was when your dad was young, we really don't know. We really don't know. And I would suggest that the sampling that suggests this was so low, was so poor, that we really can't use it. I think the best analysis would be if I think there's probably somebody out here who could do this in an educated way, is start when the dispensary started to market marijuana in the late 1990s and early 2000s, and if and only if they put those THC percentages on their products. Now in most states they're required to. And I think if you conglomerate that data and analyze it, you're going to get a lot better trend lines.
All right.
Does that help? Thank you. All right, now I'm out for my testimony. Chairman Edwards, Vice Chair LaRoe, Ranking Member Sweeney, members of the Ohio House Finance Committee, thank you so much for giving me the opportunity to present opponent testimony today. And I would say that it's HB 354, but I took 5 days out of this my life to go to Dallas to be with my pregnant daughter-in-law, and I came back and it's like everything changed. So I mixed up a little bit on what my bill numbers are. I apologize for that, but I'm really going to kind of conglomerate them and not talk about any one of them specifically. I'd apologize for not being directly on this particular bill. Now, my name is Mary Jane Bordon. I call myself a two-name person because Mary Jane is my birth name, right? I have been a face in the cannabis community for well over 20 years, and during this time I've been intricately involved with the plant, its legalization movement, and one of my goals over that period of time has been to legalize adult-use cannabis, which is the subject of Issue 2. And toward this end, I co-founded a half-dozen organizations, charitable 501c3s, advocacy 501c4s, political action committees. I've written constitutional amendments, given hundreds of media interviews, and under the moniker of Mary Jane's Guide, I've published over 100 articles for the Columbus Free Press on this, 8 of them focused specifically on Issue 2. And I work independently compensated, I hold an MBA, and I served 9 years as a market analyst and project manager for Adria Laboratories. If you're from Columbus, you might remember that Adria is out in Dublin and is now the Ohio University Medical School. And so I was an analyst at that time, and chemotherapy drugs was my specialty, and I am an actual active purchasing patient in Ohio's medical marijuana control program. And as we well know, 2.2 million Ohioans voted to pass this initiated statute by a really solid 57 to 43% margin. And after passage, the effective date was December 7th. So it's my understanding that Issue 2 is now the law of the state of Ohio. So I'm going to cover a couple points here, okay? And I'm going to start to my points. Now I'm going to start with, I hope you're familiar with Senate Resolution 216. You're familiar with that? And it's one of my greatest fears that the General Assembly will use that document, the basis for its anticipated changes. And with all due respect to the Senate, this is a grave mistake. This document is riddled with errors, omissions, redundancies, and falsehoods. It's quick. It was a sloppy composition, and its publication by out-of-state players. And as I like to say, I'm an author, and so if you read my October 2023 article for the Free Press, you can see I dissected it, and I would give it at best a grade of C. All right? And now, if you go into my testimony, and if you have the online version, if you have the PDF of it, you will see all links to all these articles that I've written. You can read them for yourself. So that was one point I want to make. Please, don't base what you're changing the Issue 2 for on this document. It is incorrect. All right? Now, again, we talked about this a little bit. Somebody else said that we, as the Ohio medical marijuana constituency, really didn't know what we were voting for. I kind of beg to differ with you because, as you can see, what my background is here. I kind of recited through what I've done, but I think that my publications, for example, my Free Press articles, reach 100,000 people, 50, 100,000 people a week. So, and I produced, as I say, 7, 8, I think, articles on Issue 2. So I think it's fair to say there's been a tremendous amount of education out there. And that's just my contribution, not the ones from also various television channels, think tanks, et cetera. So now, The statute itself, it was written by we, the people, but it was composed by legal scholars, countless experts, and industry leaders. And I believe that their knowledge, background, and skill sets allow them to understand its market better than just about anybody else. So naturally, their understanding far outshines that of lawmakers. In my educated opinion, the ballot language is well-written, logical, and composed based on considerable expertise. So law enforcement, social equity, we've talked a lot about that. I don't think I want to go into that. I think some people have done a very good job of kind of seeing where the law enforcement provisions are going with respect to the relationship to issue 2. But I still want to emphasize as well that cannabis social equity is important. It rights the wrongs of the drug war, and it brings negatively affected individuals into the workforce where good jobs and decent salaries allow them to advance and participate in the society. And so I ask this question: shouldn't the ultimate goal of a legal market be well-paying jobs and a vibrant industry where there would be little to no direct need for funds for police? Now I addressed the issue with THC. This wasn't in my testimony, but I did have another section here about THC. And I thought the way issue 2 read, I could see where people would get confused. And I think you guys probably don't. I really don't have to go into this level of detail for you. I just want to emphasize that the way that was written, it's about the maximum content, not an average or common content. It's a maximum. So it's a maximum of, say, 35% THC for flower, not the way it was worded. Might give you some other type of inference. Let's see. So I said the THC, the course is, the THC is the best known cannabinoid and possibly the most therapeutic, because THC is very therapeutic. I want to establish it's very therapeutic. Now I'm going to do something here. This is going to sound kind of weird, but I want you to follow me here. And this is what I call my stunning statistic. I always like to do this because I think I really stun people with this statistic. The Controlled Substances Act of 1970 placed marijuana in its most restrictive Schedule 1, and that barred all research. They put like a moratorium on research. For the last 50 years, you can't research it unless you want to try to find something bad about it. There you can do it. But you can try to find its medical properties, you can't conduct research. So in 1976, scientists at the National Cancer Institute found in their study anti-neoplastic activity of cannabinoids that THC retards tumor growth. And this has been borne out in many more recent studies, particularly with gliomas, all right, retards cancer growth, all right? From 1970 to 2023, 27.1 million Americans died of cancer. Maybe that you know a friend, a relative, a coworker. What if the cure for cancer lay right there under our feet, under our noses? What if lawmakers had taken a less restrictive approach, legalized marijuana, thereby permitting its research as recommended by the Shafer Commission report 1973? What if just half of those cancer deaths could have been prevented with THC? Just half of them. That's 14 million people. Let that sink in. 14 million people could have been spared the agony that is cancer. So my point is that as opposed to being a boogeyman, THC is actually very beneficial. Under the cancer scenario, more THC at the higher percentage levels could be a very good thing. And I want to say something. This is a personal statement on my part. I'm a witness. I was diagnosed with the worst type of breast cancer that you could possibly have, which is called triple negative, and most of the time, oftentimes, chemotherapy doesn't even work. So in lieu of chemotherapy, which is something I'm incredibly familiar with because that was what I studied in my days at Adria. That's what I know about. So I I refused. I actually refused. I went to my doctor and said, I'm not taking chemotherapy. I'm not doing it. So instead, I opted for THC, with a very heightened potency THC called RSO, Rick Simpson oil. And that should be, in Ohio, it's only a 70%, but it's really supposed to be higher than that, which would be, I'd say, 90, even 100%. So I opted to use the RSO in the program because I want to be able to talk to you today that when I had the cancer surgery, I did have the cancer surgery, so they went to take the tumor out, and guess what? Because I had taken the RSO, I think, there was no sign of the cancer. And to this day, to where I'm standing here right today, I'm cancer-free, and I've been so for 3 years. And I credit to RSO. And that's the power of THC. All right, let's move to homegrown. So, like I said, when I talked about home growing here, I was referring to basically what the analogy to beer and wine, because the whole point of the RMLA, regulate marijuana like alcohol, initiate statute, was to what? Regulate marijuana like alcohol. So alcohol and allows to be, you can brew at home, you can vent at home, and so it doesn't make sense that you should be able to grow at home if this is kind of an analogous way of looking at things. So home grow is permitted in 22 other states, so it's not a particularly foreign concept. And 50%, and in fact, all 50 states permit home brewing and venting. And there's an age-old idiom, grounded in English common law, that says the rule of one's space is his castle. You know, my castle is my space here, and it should be, inviolable. And so in that space, in theory anyway, we know that's not quite true, that I should be able to do anything I want within it, including the personal freedom to grow a few non-commercial plants or brew a little non-commercial beer or wine. Now I have in my Mary Jane's Guide, that's at the end of my testimony, you can find an article that I did really detailing home growing, so I don't think I'll go further than that. But like I said, a lot of things I'm talking about you can read about in the links that follow my testimony, okay? This is one thing. I'm going to move here. I'm going to try to do it quickly because I know everybody probably wants to go to lunch. One thing you haven't talked about is the 280E. All right, 280E doesn't allow these cannabis companies to take ordinary business deductions, only cost of goods sold, all right? So the 280E is predicated on cannabis's schedule as a Schedule 1 or 2. If it were higher another schedule, 280E would be allowed. All right, so what you guys could do, and I don't know, you might want to reschedule because I believe in the context, at least of the medical marijuana law, cannabis was a Schedule 2. Surely, what we're talking about with adult use, we're not talking about a Schedule 2, we're talking about a minimum of Schedule 3. So, but I'm not going to be the lawyer or the accountant to tell you exactly the direction you should take here, but I can tell you that if you can address that like Illinois did, you can help our cultivators and processors and businesses at the state level take those ordinary business deductions. So I really would like you to consider that in the context of your revisions, all right? Now, I'm going to make a statement here just because this has been a pet peeve of mine, and I saw actually it was on the news today, and that's fentanyl. I hear so many times saying, oh, marijuana's laced with fentanyl, we got to do this because marijuana's laced with fentanyl, we got to do that because marijuana's laced with fentanyl. Marijuana is not laced with fentanyl. Medical News Today states that there are no scientifically verified reports of fentanyl combination in cannabis products. Why? Why would not that be? Well, guess what? Because when we use cannabis in some way, we decarboxylate it. I think I got that word right. And we burn it somehow. You even vaporizer heats it. When you smoke it, you heat it, and that destroys the fentanyl. And if you ingest it, it's broken down the liver before it gets to the brain. It's unsustainable in heat, cannabis smoking, and vaping. So as Forbes put it, here's the way Forbes put it. Marijuana laced with fentanyl is either so rare as to pose a risk more remote than 1 in a million, or it's a total myth. My husband got me up this morning and said, you got to see this segment on one of those news shows, and it was about fentanyl, and basically saying this is a big lie, big exaggeration that is being told by our public officials. And I want to stop it, all of you guys, and say, let's educate you and say this correctly. Fentanyl is certainly not a drug that you want to be out using in a party situation. It is tragic, the number of people that it has killed, but is not being laced with marijuana. Okay, I want to go to another thing here real quickly, federal scheduling. Now, federal scheduling, in 1970, President Richard Nixon and started the war on drugs, and they wrote the Controlled Substance Act, and they put marijuana in Schedule I, and they only put it in there on a temporary basis. Remember, I talked about the Shafer Commission report, which was written as a report to President Nixon saying where exactly how we regulate marijuana. And the Shafer Commission report recommended decriminalization. Well, Nixon took the Shafer report and threw it in the trash can. All right? So we've had 50 years of the Controlled Substances Act having marijuana in it, and it never did belong in it. So now we have, it's well known that President Biden has instructed the Department of Health and Human Services to reevaluate cannabis Schedule I status with an eye toward rescheduling it as a Schedule III or lower. My personal opinion is cannabis shouldn't be scheduled at all because, well, is alcohol scheduled? Is tobacco scheduled? No. But let's leave it at this point right here, okay? So the HHS had completed its reevaluation, and it forwarded its opinion to DEA to reschedule cannabis as Schedule III, all right? Now, the DEA has to approve it, but they say in all likelihood it will. So we should say, and it could do it by the end of the year, all right? So it could deschedule by the end of the year. Now, it's going to have a major impact on cannabis policy because now with the descheduling, you'll be able to cross state lines. Obviously, you'll have a different taxation because 280E would be permissible. You could actually do research. I want to see the research done with cannabis so we could get it to patients who have cancer and have the same response that I had. That's why I really think this is important to get that research out there. And all of those would affect adult use cannabis in Ohio, and the rules being put in place. So I recommend to the General Assembly, there was such an interest in moving quickly. We've got to get this done by December 7th. Got to get this done by December 7th. Well, it's not a little past December 7th now. But I think that urgency to get it done, I really suggest it might be wise for you all to wait until that rescheduling decision comes through from the DEA and actually is formalized by the FDA and the Biden administration, particularly if it's going to occur by the next couple of months. Particularly, it's going to probably occur before the election because I imagine that Biden's going to want to campaign on that. So I think it's real wise for you guys to kind of wait. Let's see how that rescheduling goes because really, all the rewriting that you're doing now might have to be redone again in a month. So I think that's something really good for you to consider. I was going to complain a little bit because you guys had a whole bit of chances to make a lot of these changes during the initiated statute process because it allowed you 4 months. Remember, I think Secretary LaRose gave it to the General Assembly around beginning of January this year. You'd have 4 months from that until April to do a lot of these revitalizations just on your own. It would be perfectly legal, and you didn't do it. And so now, here we are at the 11th hour, and they're trying to do it, trying to revise it. It's kind of has a really icky feeling, don't you think? So anyway, here's my final thoughts. As mentioned earlier, Issue 2's ballot language is well written based on the considerable expertise of legal scholars, industry players who composed it. Still, you guys are intent on making changes, and really, I think controversial, really poorly considered changes in many ways, and hopefully you're not basing on that Senate resolution. And some of the changes, like the public smoke, the advertising show, the THC levels, all these are overseen by a regulatory body, and they're charged with crafting some of these very things that you guys are talking about. And so I ask that you please give the initial time to roll out as intended. Let these agencies develop some of these regulations and obviously if the General Assembly doesn't like it, they have a tremendous amount of influence over there and can. But let the process play out as it is. So I think the wise move, a considered impact of rescheduling, delayed modifications until the impact is known is better. It's a better strategy for you. And so remember, it's we the people who drive democracy, freedom, liberty, and even your jobs. Please respect us, all 2 million of us. So I'm going to thank you for your testimony so much. I'll happily answer any of your questions.
Thank you for testimony. Are there any questions from the committee? Seeing none, thank you.
Thank you.
We'll now call upon Alex Sandorf. Welcome to committee. Floor is yours.
Thank you, Chairman Jones and Vice Chairman Sweeney and the rest of the committee. My name is Alex Sandorf. I am the lab director for Lighthouse Sciences. I've been in the cannabis industry now for 15 years. Currently, we are a standalone processor here in Eastlake, Ohio, just east of Cleveland, Ohio, and I came today to speak about the potential changes or potential for a cap on THC levels with processed product. And my hope was to offer a little bit of clarity from the point of view of a cannabis scientist and someone who's been doing this for a living for 15 years now at this point. It's very concerning to see these proposed limits and caps in the market, mostly because it's not really viable from a physical perspective. Now, I hear a lot of misinformation and misunderstandings on that. When you're operating extraction equipment, there are no dials or knobs you can turn down to lower the potency in the products. And this term potency is a little bit of a misnomer. It creates a little bit of a misunderstanding. The way to look at it is really in purity. Your average cannabis extract coming out of a processing system or your primary extraction equipment is going to be anywhere from 75% upwards of 95% in active THC, plus a combination of other cannabinoid compounds, whether that be terpenes, esters, flavonoids, and other beneficial cannabinoid compounds, including microcannabinoids. To take a product and then cap it, what the state would then be mandating processors do is essentially have to adulterate the product. There are no safe ways to really dilute it down. Terpenes can be used to a degree, and that's what's used in vapes. But terpenes have a kind of a maximum cap of roughly around 10% that can be safely added to a cannabis vape or a cannabis concentrate to have it down to a vapable level. Anywhere past that, you run into viscosity issues, and it becomes very harsh and unpleasant to consume. Whereas a properly made extract, I understand the high level of THC can be alarming to those from outside of the industry. And I want to assure you, really the way to look at it is a high level of purity. We have a system currently within the medical program mandating dosage control, and that's really an important fact to look at with regards to these potencies. When you take a cannabis concentrate, the final end user, whether that be a patient in our medical program or an adult in an adult use and recreational program, they're consuming a very small amount. It's a much lower amount than you would consume through flower. The overall amount of cannabinoids you're consuming ends up being roughly the same, but you are getting a much purer and cleaner experience. And often for patients or adult cannabis users that might have lung or bronchial issues where consumption of flower itself is not possible, cannabis concentrates and vapes can be a lifesaver for them and be the way that they are able to interact with and experience their medicine. Setting these limits would set a dangerous precedent with regards to patient safety. We've seen this happen in California. In fact, I was one of the industry personnel on the forefront working during the vitamin E acetate scare and outbreak in California. I worked very closely with the BCC as well as several other investigative and journalistic outlets to help determine what is going on and educate the public with that health scare and crisis coming from black market vapes that were being adulterated and cut with a compound called vitamin E acetate. I think one area of misinformation and misconception we see is a lot of people look at this like alcohol. You have say 190 or 200 proof ethanol, you cut that down with water, and now you have essentially vodka. THC is a different compound entirely. It's not water soluble. It's oil soluble, and it's compatible with terpene compounds, which are naturally occurring hydrocarbons. But the only way to really dilute it down is with compatible compounds, namely fats, oils, and lipids. None of those are safe for the lungs or things that you would want to have in your lungs. In fact, that was the vitamin E acetate scare. Vitamin E acetate is a heavy lipid or an oil, and it can cause a condition called exogenous lipoid pneumonia, which is what the the sad individuals that were unfortunately exposed to that compound were diagnosed with. As there's no real way to safely dilute it down, you end up having to use microcannabinoids. Those have severe disadvantages. You're bringing in hemp-derived products. They can be harsh and high concentrations, and you're really forcing the market to either use an unsafe or potentially unsafe or undesirable adulterants to cut down the efficacy of the medicine and the product that the residents of the state of Ohio have asked for. The other issue is it creates a product that's extremely undesirable, economically speaking. And there will always be those individuals that will seek to fill that gap, that will seek to meet that demand, whether that's more entrepreneurially minded people that are operating what you might call the illicit market or the black market, which the goal of any program should be to seek to reduce that impact with regards to the legal market, and also with regards to tax dollars leaving our state, going across the border to Michigan, where high potency, high purity, safe tested products are available. Hopefully we can get around that and set the limits at or above what was currently passed by voters on issue 2. And it would be great for the program. It would be great for all the residents of Ohio that want clean, safe access to tested medicine. With regards to any other questions or any other areas in cannabis science, processing, anything else that I can help clear up for the committee, I'm happy to provide insight on that as well. Thank you.
Thank you for your testimony. Are there any questions from the committee? Hearing none, thank you for your testimony.
Okay, thank you all.
We'll now call on Maggie Lutterus. Is she in the room? Her testimony is listed as written, but she is here, so it's the next to last testimony on your iPads. Welcome to committee. The floor is yours.
Wonderful. Chairman Edwards, Vice Chair LaRae, Ranking Member Sweeney, and members of the House Finance Committee, thank you for the opportunity to provide opponent testimony on House Bill 354, a bill that would revise the adult use marijuana program established in Issue 2. My name is Maggie Lutterus. I am the Advocacy and Public Policy Coordinator of Prevention Action Alliance. PAA is a statewide nonprofit prevention agency based in Columbus, Ohio, and has been in existence for over 30 years. Prevention Action Alliance is dedicated to leading healthy communities in the prevention of substance misuse and the promotion of mental health wellness. Our organization offers an abundance of resources, trainings, services, grants, and advocacy opportunities for those who are active in prevention and mental health fields. PAA requests that this committee maintains the current language as provided in House Bill 86 that reduces the potency from 90% to 50% of the extracts. Studies have found that direct associations between how much a user ingests, how regularly they ingest, and how strong the THC is with increased risk of the development of the mental health issues. People who start smoking marijuana heavily in their teens and have an ongoing marijuana use disorder lose an average of 8 IQ points between the ages of 13 and 38. These lost mental abilities do not fully return to those who quit marijuana as adults. People who use marijuana are more likely to develop psychosis and long-lasting mental disorders, including schizophrenia. The association between marijuana and schizophrenia is stronger in people who start using marijuana at an earlier age and at a more frequent rate. By reducing the THC content, extract cap percentage, youth and young adults will be protected and more likely not experience many negative health impacts. PAA also supports the Senate version of HB 86, reduction of homegrown marijuana. The homegrown language in Issue 2 would have allowed for a thriving underground and unregulated market activity to continue a portion of their cultivation functions legally. Issue 2 language does not have any plant limitations, allowing unregulated growth and unknown amounts of marijuana being produced. A reduction of homegrown marijuana plants will reduce the likelihood of an expanded unregulated market that operates outside the law enforcement jurisdictions. With homegrown increasing access to marijuana, PAA is also concerned for the surge in accidental children exposures and consumption. As medical marijuana became legal, Ohio saw an increase in accidental marijuana poisonings in children. Although we are pleased to see the Senate version, there is some funding in marijuana substance abuse treatment funding and education and community and prevention programs should also be specifically identified and earmarked. PAI recommends that a portion of this fund should be allocated to age-appropriate evidence-based prevention education for K through 12 schools as well as Ohio's colleges and universities in partnership with the Department of Mental Health and Addiction Services, the Ohio School-Based Excellence for Prevention and Early Intervention, the Department of Education and Workforce, and the Department of Higher Education. Effective school-based prevention programs generate $18 in saving for every dollar spent and go beyond just marijuana prevention, but other substances and addiction preventions. In addition, a portion of this fund should be allocated to support community prevention coalition programs and activities across the state. Ohio has 92 prevention coalitions and 62 suicide prevention coalitions across the state that do impactful advocacy and programming that details the behavior that leads to a substance use disorder diagnosis. Each community is unique, and so is every prevention coalition. As prevention coalitions identify prevention strategies to meet their community needs, it is imperative that funding within the substance abuse and addiction funds be available that is flexible, equitable, and accessible across all communities in Ohio to implement community-specific prevention strategies. As each prevention coalition is different, so are our communities. PAA would like to see the home rule authority that would allow for townships, cities, and villages to be regulated and zoning and prohibited marijuana operations in their communities. PAA would also like to see the host communities fund be expanded to all communities, as it incentivizes municipalities to allow and even encourage dispensaries in their communities. The fund was set up in issue 2, also did not allow counties the ability to receive funding, where many rural counties rely more heavily on county services rather than municipal. In addition to home rule, PAA recommends that when a license is granted to a dispensary, cultivator, or processor, that there is an appropriate political subdivision that has jurisdiction of the location of the marijuana operator receives a notification, such as political subdivisions do for alcohol facilities. Thank you, Chairman Edwards, Vice Chair LaRae, and Ranking Member Sweeney for the opportunity to provide testimony for HB 354. I'd be happy to answer any questions at this time.
Thank you for your testimony. Are there any questions from the committee? Seeing none, thank you for being here.
Thank you.
We'll now call on Cody Marica. Is Cody present? He's left. That marks the end of our submitted testimony. Do we have anyone from the public that would like to testify? We ask that you'll fill out a witness form if you have not done so yet.
I did yesterday and sent to Representative Edwards.
What's your name?
Matthew Osler.
Matthew Hostler. Do you have that? We'll have to make sure we get one for you, so we have to ask you to fill another one out today.
Sure, no problem.
All right, thank you. Floor is yours. Welcome to committee.
Thank you. Good afternoon, honorable members of the committee. My name is Matthew Osler, and I'm here representing my company, Canopure Relief, LLC. I'm here today as a constituent and an existing indoor hemp farmer and processor operating in Nelsonville, Ohio, a small town in southeastern part of our great state. I would like to express my thoughts regarding House Bill 354 and its potential impact it may have on the hemp industry in Ohio. As someone deeply involved in hemp cultivation and processing since its inception in Ohio in 2020, I believe that existing hemp farmers should be given priority access to Tier 3 adult use cannabis cultivation and processing licensure under the new legislation. The expertise gained through diligent effort and hard work to operate in compliance with strict oversight from the Ohio Department of Agriculture uniquely positions us to contribute significantly to the broader cannabis market. We are equipped with the necessary knowledge, experience, and facilities to produce cannabis that is safe and in compliance with the adult use program, making us a valuable contributor to the state's growing cannabis industry. Granting priority access licensure to existing hemp farmers under the new adult use program not only acknowledges our years of dedication to the industry, but also ensures smooth transition into the expanded markets created by House Bill 354. This approach can foster a sustainable and competitive cannabis industry in Ohio, leveraging the existing resources of hemp farmers like myself. I strongly request that provisions be made to Ohio Bill 354 that prioritize existing cannabis hemp farmers when it comes to the allocation of adult use cannabis and cultivation processing licensure. This step would not only recognize the contributions of established hemp farmers, but also contribute to the success, growth of the cannabis industry in our state by the people of this great state. I'd also like to bring attention to the language contained in House Bill 86, particularly regarding full-spectrum hemp edibles and tinctures. It would be of great detriment to Ohio hemp farmers and processors who have been producing full-spectrum products since 2020. I understand the dilemma that you are facing with hemp-derived THC products. However, full-spectrum hemp companies have and don't participate, that don't participate in hemp-derived Delta-8 or other hemp-derived THC products. Full-spectrum hemp products offer exceptional relief to our customers, and our products only contain trace amounts of the Delta-8 THC compound that are naturally occurring in the plant. Thank you for your time. I'm open for further discussion or questions at this time.
Thank you for your testimony. Questions from the committee? Hearing none, thank you for being here and thank you for your patience.
Appreciate it.
Are there any others that would like to testify?
My name was called early today, so that's why I missed it, but my name is John Lutz.
John Lutz, okay. Welcome to committee.
Thank you.
Floor is yours.
All right, appreciate that.
And your testimony should be on the iPads.
Yeah, I did send it yesterday.
Yep.
All right, thank you. Good afternoon. My name is John Lutz, a.k.a. Johnny Cannabis with OhioCannabis.com. I would like to thank our state representatives for allowing me the opportunity to speak in the People's House and for having open discussions in order to properly create and set forth precedents within the new legalized Ohio cannabis home-grow community and adult use industry. OhioCannabis.com was founded in 2016 as a news, media, and lifestyle brand and website. I have worked at a very high level within the industry, and we have provided information free of charge to tens of thousands of Ohioans about the legalization of cannabis in Ohio. Our brand is well known and a trusted source of information. Now, I'm speaking on behalf of home growers and how the program needs to move forward to freely allow the proper access to genetics within the Ohio cannabis home grow community. It was amazing to see 2.1 million Ohioans turn out in force to pass this with a landslide. This is truly a historic time to be at the end of Prohibition and at the beginning of a new legal landscape for the Ohio cannabis home grower. This is a craft hobby that is rich in culture that many Ohioans are very excited to be a part of. It allows them to explore botany and agriculture, and that is always a benefit to society. Setting it up correctly is extremely important so that we can assure a safe and well-run community full of people who respect the program and are very excited for this opportunity. Ohioans have proven themselves mature enough to handle a legal cannabis market. They've shown this over the past 7 years under the medical program, as well as self-control at over 100+ cannabis-focused events in Ohio since 2016. I have personally put on a cannabis event at the Columbus Convention Center in 2017. They've all played out flawlessly without any issues or police intervention. Now, based on the 2018 Farm Bill, as well as a statement from the DEA in 2022, cannabis seeds, clones, and tissue cultures have less than 0.3% THC, are considered hemp, and are no longer listed as a scheduled item. This seems to have been reflected in House Bill 86 by removing inferior language set forth in regards to transferring plants in Section 3780.29 A of A3 of the Regulate Marijuana Like Alcohol Bill. To me, this is a move in the right direction with House Bill 86 and a positive update for the home grow community. Essentially, what you have is the equivalent to a tomato cutting. While beautiful, it is inert, harmless, and should have no bearing on a new home grower's process or plant count. The new language in House Bill 86 needs to be updated to reflect the allowance of 6 flowering plants. The clone or vegetative state should not have any bearing on our plant count since they are inert and allow home growers to have a perpetual grow so they don't run out of medicine for themselves. You can easily buy seeds, clones, and tissue cultures online and have them shipped directly to your house. There shouldn't be any restrictions on any of these for home growers. We are trying to bring the industry into the light so the people are more comfortable and feel safe participating, and also stamp out any illegal activity. The black market has existed in Ohio for as long as anyone can remember, and it is currently valued at a $2 billion illegal industry still. Now, if you're familiar with the way beer is made, they use a flower called hops, which provides its unique flavor and aroma that so many people enjoy. It is also part of the Cannabiceae plant family, yet no additional oversight is given to this plant material or its sources when a home brewer decides to make their own beer. The same should apply for home growers because we are regulating cannabis like alcohol, right? Now, in regards to the 2.5-ounce limit of flower, I think it's rather low. Most big municipalities throughout Ohio have already decriminalized 200 grams of flower in most places, which is almost 8 ounces. So why are we going backwards then and setting such a low limit for home growers? This is going to put some home growers over the limit, and that's something we should try to avoid. Also, why are there no taxes going to any type of child development or school programs, and yet everything going to just build a bigger prison system in Ohio? It sounds counterproductive to a lot of the arguments for legalization. Also, diluting concentrates down to 50% only creates an inferior product that will have garbage fillers and additives in it, something no one wants. The point of legalization is to keep people safe and allow proper access. We're losing millions of dollars of money to Michigan because our taxes and prices are too high, and people will continue to go there to get better quality products at a cheaper price. In my last words, I respectfully ask our elected state representatives finalizing details within the new home grow program guidelines to not place any criminal rules or oversight on a home grower trying to legally acquire new genetics. Thank you, and have a great day.
Thank you for your testimony. Are there any questions from the committee? Representative Richardson?
Thank you, Chairman, and thank you for your testimony.
Thank you.
I'm just wondering, you talked about limiting to 6 flowering plants for home grow. How do we enforce that?
And that goes into the home grow program in general. We're obviously giving people so much room to be responsible adults. People have been breaking the law this whole time. You know, the people that have been breaking the law will continue to do so. What we're trying to do is set up a program that people will follow guidelines and rules of and won't do that. Now, when it comes to separating vegetative growth with flowering growth of cannabis plants, it's very apparent when a plant is in flower. They do, within a couple of weeks of being in flower, they do grow beautiful flowers on them, and it's very apparent that they are in flower. And to lump the vegetative plants and the flowering plants together, you just can't do that because they are 2 totally separate stages of development, and that even includes a 3rd beginning stage of clones or seeds. So how do you enforce it? I think you just have to have good guidelines and rules that the people are going to agree to abide by, and from there, you know, it's on them to do that. If they get out of reach of what they're supposed to do within the program, then they're going to have to, you know, pay for that through the legal system. But
Follow-up, Chairman?
Follow up?
Thank you. And I'm so sorry if I just interrupted you. Did you have another thought?
No, you're good. You're good.
Okay, thank you. No, I just was wondering if we kept it to 6 flowering plants for homegrown, would that satisfy home growers' needs?
It would, because that flowering designation is extremely important for the guidelines, because what you would theoretically have is then 6 plants in vegetative ready to go into flower once your current crop is harvested. It's called a perpetual grow, and if somebody's trying to grow this for medicine for themselves, they need to be able to keep that grow consistent. So if you have a downtime, and it can take anywhere from 30 to 90 days to veg out your plants to the right growth before you would want to flip them into flower so that you get the end result of the cannabis. They're going to need that 30 to 90 days of a window to get those plants at the point where it'll be good to go into flower. If you have that downtime, then people, especially with the low limits at 2.5 ounces, people are going to run out of medicine. And I call it medicine still because we're coming from a medical program, and whether you use this for cancer or pain management or anxiety or just because you had a hard day at the end of the day, you know, it's legal now. We're allowed to do that. And if people are missing out from growing their own, that's when they're going to go looking in the black market and try to find another source because their needs aren't being met by the rules and guidelines of the home grow program.
No further question. Thank you.
Thank you. Representative Crothers.
Thank you, Chair. Through the Chair, thank you for coming today. I know it's, first of all, very stressful to come up here and stand in front of a bunch of people or just a few people. How many plants would you say, or flowering plants would you say, would be recommended then for home grow?
The people voted on 12,
Okay.
you know, and the language wasn't clear in that either.
No, it wasn't.
Flowering plants, and that particular wording is extremely crucial to this program.
So 6 flowering,
At
6
minimum.
non-flowering.
Correct. At minimum, 6 flowering plants
Okay.
and 6 allowable vegetative plants.
Follow-up?
Follow up, go ahead.
Thank you, Chair. How would you feel as some of the tax dollars, and please understand that because there are tax dollars, and I believe Michigan taxes also with this, I don't know. It's pretty obvious that some of us have never imbibed, but certainly have been around it for a number of years being older. What would you say if some of the tax dollars went to things like school safety? Or, I mean, we give a lot of money statewide to schools, but something like school safety programs or something like that, how would you feel about that?
I think if you look at a state like Colorado that has had a legal market for well over a decade at this point, their streets are beautiful, their school systems are top-notch, their teachers and administrative are paid well. Even though the schools are funded, they're always underfunded across the whole state. So additional funding to school systems or child development programs is always going to be beneficial. You know, there's things like STEM that really need to be extrapolated upon here in Ohio to really get more engineers and scientists and stuff involved in a lot of things like that. So yes, I mean, like I said, all of the taxes seem to go to be building a bigger prison system. Ohio, I think, is the 3rd or 4th largest prison system in the whole country. We have a pretty good system. I don't think we need more. Obviously, more funds will be allocated towards law enforcement and prison systems and stuff like that. We're probably not going to be able to stop it, but I think we can reduce it and then move those funds to some type of child development or school programs for sure.
Follow-up?
Follow up.
During the state budget, we did a great deal of that, tremendous amounts of money, if you look. So what I'm asking is, we seem to have a great deal of people concerned about school shootings and some things like that. What I'm asking is a school safety to keep the kids in our schools safer.
I would say yes. I mean, this is my son here that came with me. He's 19 now, but you know, I'm speaking from a father. You know, it's our children are our future, and as a father, it's one of the most rewarding things I've ever been a part of. So keeping our children safe in such a turmoil time in this country and history, things are unfortunately probably going to get worse. And anything we can do to keep our most precious things safe, I'm all for. Thank you.
Thank you. Any further questions from the committee? Hearing none, thank you for your testimony.
I appreciate your time. Thank you, everyone.
Seeing no further testimony, that marks the end of the second hearing for House Bill 354. And with no further business before the committee stands adjourned.